My lord, may I be permitted to mention in original side matter? My lord, I'm aware that your lordship takes the original side mentionings at 2 o'clock, my lords, but there is some urgency, my lords, in this matter. This main CS 286 of 1976 is returnable on 6th of January, Monday, for confirmation of sale. My lord, we want to participate in the sale proceedings, my lord. We have taken out an application, it is affirmed. My lord, I just needed a leave to short serve, my lord, so that it can appear on the 6th along with the main CS.
Take it up. Take it up. Mention this.
Inclusion motion group 1. Inclusion motion group 1. The contempt application order.
List.
Item number 1.
Yes.
Now, I have handed up to your lordship the orders passed in the proceeding. Those copy I have handed over to your lordship, my lord, which I took the inspection.
এগুলো খুলে দিন। Yes.
kindly have a look at the method before I proceed further. Although at last occasion I submitted before your lordship, I have shown this provision. Once again, my lord, kindly turn to section 11, proviso to section 11. Once. This is, my lord, the award inquiry.
Yes.
On the day so fixed, my lord, section 11. On the day so fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections if any which any person interested has stated pursuant to a notice given under section 9 to the measurement made under section 8 and into the value of the land at the date of publication of the notification under section 4 subsection 1 and into the respective interest of the person claiming the compensation and shall make an award under his hand. Now, this is the criteria. Then, my lord, provided no award shall be made by the collector under this subsection without the previous approval of the appropriate government or such officer as the appropriate government may authorize in this behalf. So this is a mandatory in nature.
He makes such a without such a clause. Okay.
Next proviso, my lord, in respect of my lord, my learned friend will correct me. If it is made below 15,000, 50,000 or something like that, then no approval is required if the government may notify. But in this case, that is not such a thing, because I tell you, lordship, why? Because they sought for approval. Kindly turn to, my lord, page 10 of the order sheet. And he marks the two dates. One is order number 16 dated 7th February 2003. Schedule verification made done by Sri Amit Bose, Assistant LO. Accordingly, award has been in terms of 12, 13 and 13A, including a calculated note, is placed herewith which may kindly be approved. Next, my lord, another note dated 11th of February 2023. Just below to that. Award in form of 12A may be approved and signed. Kindly see, may be approved and signed. So admittedly, up to this period, no approval was granted. Then, my lord, kindly turn to the next page. There was a note that has been struck down. Then, 17th February, order number 17, award has been declared. So, my lord, my respectful submission before your lordship will be this. There is no document to prove this, your lordship, that award was approved. I tell your lordship why this has not been approved. Subsequently, my lord, kindly turn to the next. Immediately below to that. Estimated amount. Once the award is been declared, question of estimation does not arise. It's an offer, attain finality the moment award declared. And it attain finality the moment it has been submitted with the office of the collector. If your lordship kindly turn to section 12. Kindly turn to section 12. Such awards shall be filed in the collector office and shall, except in area provided, be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, or of the true area and value of the land and the apportionment of compensation among the person interested. Now I have 2-4 submission before your lordship. The 3 things is required to be indicated in the award. That true area, apportionment, and the land value. It is irrespective whether I appeared or not. There is no scope for declaration of an award not verified. I do not find any such provision in this statute. Because the award can be passed only after verification, only after the inquiry is being conducted. And that to pass, my lord, the true area, value of the land, and the apportionment of the compensation. If everything is being done, there is hardly any scope to say that not verified. I tell you, Lordship, why I will saying this. Now kindly turn to my lord. The word, the page 11, estimated amount of rupees 1,09,84,556. Verified amount is rupees 64,000. So this is an estimated amount, out of which verified 64 lakhs. Accordingly, sub allotment of fund may kindly be made. But I could not follow this. I am very poor in English. But even then I could not follow this. If award declared, what is the question of the fund? There cannot be two sets of award. In this case, exactly what has been happened in this case. If you lordship kindly see, the language is an award. Section 11, kindly see, my lord. The last word, and shall make an award under his hand. Section 11. Make an award.
Yes.
Now, my lord, kindly see. Then, my lord, the sub allotment rupees 64 lakhs such and such. Then, my lord, payment. Kindly have a look at the date of payment. All has been prepared. Next date is, my lord, 17 February 23. 17 February award has been declared. And on the very day, payment has been made. Unheard of. Can't be. Because you have to file this with the collector office. Then only, my lord, kindly turn to, my lord, the notice under section 12. When this notice can be issued. Kindly have a look at the, my lord, section 12. On the same day, award declared 17 February, payment has been made 17 February. Without indication how the notice under section 12.2 has been served. Kindly turn to, my lord, subsection 2 of section 12.
Notice award to such persons interested. Oh.
Subsection 12.2, my lord, kindly have a look at the subsection 12.2.
Hmm.
This notice is to be served. This is next to impossible, my lord. I never came across such a proceeding that award has been declared on 17th and payment has been made on 17th. How the notice is being served? 12.2 says, my lord, the collector, after this submitting with the collector office, the collector shall give immediate notice of his award to such of the person interested as are not present personally or by the representative when the award is made. Then, my lord, your lordship will find
12.2 is a question giving notice will arise if a person is not present personally.
there is no case that at the time of inquiry, these are the persons who are present.
Okay.
At the time, there is not their case. That these are the persons who are present. And moreover, my lord, if I suppose I am not present, I am present at the time of inquiry, may I put it to myself, how could I know that when the award is going to be made? This is not the case. These are the persons at the time of declaration of the award, they were present and they were made payment.
Okay.
Then, my lord, lordship kindly see. Then 27 February 2003, lordship kindly see, my lord, page paragraph 13. I shown to your lordship, my lord, the provision that this is the conclusive evidence in between the collector and the person is interested. Thereafter, nothing can be done other than the exigency, my lord, required under section 13.
Yes.
Then kindly turn to paragraph 13. Page 13, my lord, order number 19.
Yes.
Whereas it appears from the case records that a good number of awards is yes. Now, my lord, good number of award is lying undisbursed after payment of award as per program. A large number of people are attending office regularly claiming compensation of land thus acquired with a complaint that they were not aware of acquisition proceeding and as such could not submit their claim in due course and their names do not figure in award. It is a fact that public notices were published at Gram Panchayats, municipalities and other local offices inviting all interested persons to put their claim, and also individual notices were issued upon the recorded right as per record of rights. But a considerable number of persons did not turn up with the relevant documents to establish their title, my lord, ownership interest over the acquired land. It appears that the claimants are mostly new purchaser and their interest was not reflected in the finally published record of rights. Also, it appears that in some cases, award has been declared on the basis of the last record of recorded tenants who are either dead persons or who have disposed of the land. So, in order to overcome the aforesaid problems, verification of the said claim whenever there are claimants other than person those names figure in award may be done after observing all formalities as per order such and such. Now, Lordship, kindly see, my lord, once again, my lord, section 13. Section 13. If I say, my lord, that this award is award is attained, the finality is a conclusive evidence between the collector and the person interested. Now, kindly turn to section 13A. How the correction can be made. And that can be done by the collector, not by the additional land acquisition officer.
Yes.
13A. The collector may, kindly see the language, the collector may at any time, but not later than 6 months from the date of the award or where he has been required under section 18 to make a reference to the court before the making of the such reference by order, correct any clerical or arithmetical mistakes in the award or errors arising therein, either on his own motion or on the application of any person interested or a local authority, provided that no correction which is likely to affect prejudicially any person shall be made unless such person has been given a reasonable opportunity of making a representation in the manner. The collector shall give immediate notice of any correction made in the award to all the person interested. Now, my lord, now kindly see what happened thereafter. Paragraph 15, page 15. I shown to your lordship the clerical and arithmetical correction can be made in the award. That too by the collector, not by the rank below to the collector. Now, it is an order number 21, 7th August 2003. Post-award verification made by such and such person. Statement showing the reflection of the post-award verification in those herewith, enclosed herewith. Accordingly, award has been prepared for rupees 90 lakhs. But I could not follow. Further award has been prepared. And this has been sent for again approval. Kindly see. Statement and award may be may kindly be approved. This is 2003. 7th of August 2003. I shown to your lordship there can be only single award, an award. Then again, my lord sought for approval, part award. Can you see? The figure kindly mark the figure, my lord. This is 29,47,637. Kindly mark the figure. And this was statement and award may kindly be approved. So I presume, my lord, this was sent for approval. Then there is no indication thereafter that this amount was approved. Then, my lord, again turn to, my lord, the order dated 24th of August 2004 at page 18.
Yes.
Now, my lord, this is the, my lord, the 4th August. Again, the assistant LO will please hold verification of award as accorded by collector on 11th August 2004 after issuing notices to the claimants and other person interested, who will also prepare the award accordingly and put up early. Next, my lord, kindly see. Verification of award on post date has been done by assistant LO AK Bose and the schedule as reflected after verification is put up below. Award in form of an amount of rupees. Now kindly see the mark the amount. Earlier this was, my lord, 29 lakhs or something like that. This was 29 lakhs 47,637. Now award in form of the amount of rupees 5 lakhs 22,260 has been prepared by the assistant LO and the same has been checked and verified.
Yes.
Now the award amounting to rupees 5,22,260, thus prepared in form 12 and 13A, is placed below for kind approval and signature of the collector. My lord, I respectful submission before your lordship will be this. The collector is not the approval authority. Approval authority is higher than that of the collector, because collector has to declare the award and his award required to be approved. So one person who is declaring the award cannot himself approve his own award. He is not the appropriate government.
But then proviso of section
You kindly
11 says that appropriate government or of such officer as the appropriate government may authorize.
So, my lord, collector who is going to declare the award, now his award is required to be, my lord, the
Approved
approved
by some other officer other than collector.
other than collector. Or let them to come out of the case that these are the person who was authorized. Now, on this day, my lord, award was not approved. On 24th of August, award was not approved. Then, my lord, kindly see why I am saying this, those was not approved. Kindly turn to the next page, page 19, order dated 8th of September 2004. Kindly see. Now, the last part of that order, well, lordship got it. Now, this amount of rupees 5,22,000 in form 12 and apportionment shown in Form 13 and the verified schedule placed below may kindly be approved and signed in order to make payment to the claimants. Again, asking for approval. Next, in view of approval may be accorded and in form may be signed. Next, this is also 15th of September 2004. Then all on a sudden, 30th September, it has been alleged this has been court deposited. No indication when the award has been declared. Court deposited.
Where it is?
Kindly in the next page, my lord, page 20, order dated 30th September 2004. That's it, got it. Earliest for making payment to the claimant for post verification and also for court deposit of not verified award. So 2004, they are depositing with the court. By asking for court, next is 2024. Now, my lord, lordship, kindly see. They have annexed. Next page, my lord, that is the Form 13. Your lordship will find my name, the name of my mother, the mother of the petitioner, at the bottom, serial number 181. Lordship, got it. The Mouja Raigachi. Next is, my lord, 182. The plot number is 3467. Your lordship will find this has been struck down Raigachi, then it has been written Gopalpur. Now, my lord, kindly side by side, kindly see the affidavit in opposition filed by the state. Kindly look at the, my lord, affidavit in opposition filed by the state.
Yes.
Now, your lordship will find in the opposition of the state at page 20. At page 20, the same document has been annexed with their opposition. Now, lordship, kindly turn to the serial number 182.
Yes.
Now, side by side, kindly turn to the other part of 182, the same serial number. Now, your lordship will find the state used an affidavit that is has been stated Raigachi. And subsequent to filing this application, when this I pointed out during the course of hearing, this point, then immediately thereafter to rectify this thing, this has been struck down and it has been written Gopalpur. And you see, and requiring body is using this affidavit, using this document by way of an affidavit.
But these two are not the same one.
Kindly see, because this is the record. I took inspection, and this is the record filed by the state. Both the documents are these are not of mine.
These two are not the same.
So they can answer it. But what actually happened? Because state is saying that 3424333, the plot number 3467 award has been declared as Raigachi, but fact remains 3467 situated in Gopalpur. I have the original porcha with me. As directed by your lordship, I have the original porcha with me. So my respectful submission before your lordship is this: that in respect of this plot, no award has been declared. Because section 4, section 6 in respect of the plot number 3467, which is situated within Mauja, Gopalpur. Now, another interesting part is this, my lord. If your lordship kindly turn to page 13. Page 13 of the affidavit used by the requiring body.
How many acquisitions proceedings were initiated?
One. Only one acquisition proceeding.
Then why the number? Why the number is different?
I don't know. Only one acquisition proceeding, my lord. I can show to your lordship, my lord, the section 4 and section 6. Where the all the plots are, my lord, appearing. If your lordship kindly turn to the affidavit of state, at page 11, they have annexed the document. Page 11, this is the notification under section 4. These are the plots. And plot number, my lord, kindly see that Mauja Gopalpur at page 12. Mauja Gopalpur RS plot number 3467 in full. And next page is my lord, page 13. This is section 6. This is a declaration. The same plots are appearing. Same plots. Now, my lord, your lordship will find one plot number, that is 941. Nowhere your lordship will find this plot is under the under the acquisition proceeding. Your lordship will not find in this either in the section 4 or under in section 6. But your lordship will find the requiring body used an affidavit. They have annexed one document claiming the document of notice for under section 9 at page 13. The affidavit filed by the requiring body 4A, page 13.
Page 13. Yes.
That's got it. Page 13. Then your lordship will find in a handwritten. All are typed plot numbers. So this was written in handwriting 941.
As because by the Lord, it is the declaration and other things. There are all Gopalpur, but due to some mistake, it was in the Rajara. That is in the Maladikia Lordship. I must, on that point, my lord, I must submit and show that in our report of the court one, my lord, that is in our certificate in opposition, I have stated that, but if your lordship will see page 12 in our affidavit in opposition, that is originally, my lord, that is the notification is Gopalpur, but due to some mistake, it was in the written as Raigati, my lord. As because the first civil is Raigati, land civil. That is page 11.
This is a mistake.
That is by our mistake, my lord. But original, my lord, if your lordship will see the original notification is Gopalpur. There is many ambiguity. But in our paragraph, my lord, we have not stated that, my lord, we have stated otherwise. That is in paragraph, that is paragraph, page 4, paragraph, Roman 4, my lord. It's our mistake, my lord. That is my, that is our state mistake. You lordship will see that it has been found from the award details in plot number Ato and Ato of Raigas. After that, my lord, 3-4, after 4 line, RS plot number 3466 partly acquired and 3467 acquired in full of Mouja Gopalpur. No, my lord, JL number 2 award has been declared against. That is also correct, my lord. That is Gopalpur. Yeah.
Okay.
So there is, my lord, if there is anything in Raigachi, my lord, that is our mistake in that part.
And what
But
about
in our affidavit, my lord, I have stated so, and other things is there.
the LA case number?
LA case number, my lord, same
Oh.
LA case. There is many.
In the
that-
records,
See,
in
LA case number, my lord, that is the
No,
paragraph 11.
records produced, it is LA 4/7 of 2002-2003. And in the affidavit which has been annexed, it is LA 4/7 of 1999-2000. So that's why I asked Mr. Pan whether there was any other proceedings.
2000.
Yes, in affidavit page 19, page 17, all the pages.
Raigachi. By 1999 and 2000. But here 2000 and 2001.
Again, in the records that has been produced is 2002-2003.
But original, my lord, notification is, my lord, that is LA 4/7, 2000 and 2001 entry.
Which is correct.
Notification is correct.
So what will be the case number? In the order, what is the order? 2000, 2001. Then how come this?
Notification, my lord, that is mistake of, but original, my lord, is
2000, 2001.
yes, my lord. But possession certificate, my lord,
Hmm.
that is the page number 24. That is page 24, my lord, if your lordship will see. That is also case number, my lord, 1, 2, 3, 4, 5, 6 lines. 6 lines, my lord, case number 4/7, 2000 and 2001.
So form 13A is showing a wrong case number
Yes, ma'am.
in both the records produced as well as the affidavit. The correct number is in the order sheets.
Yes, ma'am.
2001, 2000, 2001.
2000.
Okay. Yes.
May I put it?
Yes, yes.
Then, my lord, I am grateful to my learned senior friend.
No, no.
I tell you, Lordship, why? Why I am so grateful? In respect of 2000, 4/7, 2000, 2001, no award has been declared. Kindly see the document. Whatever award has been declared, whatever the payment notice has been annexed, that is a 4/7 of 2002 and 2003. 2002 and 2003. And another one, they have annexed. They are saying that by mistake, it can't be the mistake of my learned senior friend, because this is the document of the state, and there is a 4/7 of 1990, 2000, 1999, 2000. Not a single piece of paper I have been allowed to inspect or they have annexed.
Again, I am interested, as Vital Bala, to clarify. If your lordship will see the entire order sheet, that is from entire order sheet. From page.
I am grateful to my landlord. I have never said that order sheet does not pertain to 4/7 like 2001. I have said that in the basis of the award, no award has been declared.
Clarify that I want.
Order does not reflect the
It is not my.
declaration of award.
Yes, he will.
Order, my lord, what order sheet does not reflect the date of the award. And these are the documents in support of the order sheets. They have annexed in their affidavit. These are the person has been paid. And this is the award declared non-verified. That is a specific case in respect of me. But case number is different. Now, proceeding initiated for section 6 in respect of 2001. Now, one document requiring body. This is the gentleman who is affirmed this affidavit. It's a government, state government affidavit document. This is within his personal knowledge. And he is saying the document he has annexed, that is of 1999-2000, 1999-2000. I do not know where from he has got this document. This is the affidavit of the requiring body. And state, what they have annexed, that is the case number is LF 4/7, 2002 and 2003. If that be so there cannot be any declaration or section 4 in the year 2000. Or if that is the correct, that section 4, section 6, no declaration, no award has been declared. At least no document has been annexed to this, either by way of an affidavit or by way of inspection I took. So as of date, on the basis of the records, the orders is I submitted to your lordship, no award has been declared. No award.
Okay. Next.
Now, moreover, my lord, and another thing is, my lord, that if within 2 years the award could not be made, then my lord, the entire proceeding starts. Entire proceeding. If your lordship kindly turn to annex section 11 capital A. Period within which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration. And if no award is made within that period, the entire proceedings for the acquisition of land shall lapse. And to this, my lord, I like to cite one decision for your lordship on of Supreme Court. And another matter I spoke to your lordship. This is reported in 2012 5 SCC, page 365. This is fine. My lord, I will xerox in and hand it to your lordship. My lord, it's a very bad condition. Relevant portion, my lord, paragraph is 8 to 12.
8 to
8 to 12.
yes.
So therefore, my lord,
The amount has been received by your client.
I have not been paid.
Money was
My lord,
deposited.
my lord, let them show a single provision to your lordship for my satisfaction and satisfaction of this court. That award can be made as non-verified, as not verified. There is hardly any scope. I shown to your lordship the provision of section 11, how the award can be made.
Hmm.
And the form, দেবে না আমাকে এইসব হ্যাঁ ওরা সব টাকা পয়সা দেওয়া
Yes.
অফিসারদের কাছ থেকে সব নিতে হয় কি করবো yes now kindly my lord this is the manual there is the kindly have a look at the my lord form number 13 and form 13A they have relied upon the form 13A in the order sheets kindly have a look at the my lord 13 and 13A and your lordship will not find a single word or a column pertain to non-verified. Can't be. If it is non-verified, may I put it to myself? When the money can be deposited, kindly see, my lord, when the money can be deposited with the court. Kindly turn to section 31. When the money can be deposited with the court, under at what circumstances? Kindly turn to the my lord section 31. Section 31, my lord, kindly have a look at it. Lordship has got it. On making an award under section 11, the collector shall tender payment of the compensation awarded by him to the persons interested, entitled thereto, according to the award, and shall pay to them unless prevented by some or more of the contingency mentioned in the next subsection. If they shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title to receive the compensation or as to the apportionment of it, the collector shall deposit the amount of the compensation in the court to which a reference under section 18 would be submitted.
Yes.
There is hardly any scope. There is hardly any scope for non-verified, and that can be deposited with the court. Because what is the intention of the deposit of the court? Suppose there is a dispute into the title, so that I can move before, I can place my case before the civil judge, where section 18 lies to claim my compensation. So the word non-verified does not recognized by the statute or by the manual. Because these are the contingencies, my lords. If one condition is being fulfilled, then court, that there may be a court deposit.
One minute, Raj. Then what is non-verified deposit? What is non-verified deposit then?
I don't know. But there is hardly any scope, because, my lord, if it is not verified, award cannot be declared. Because when award can be declared taking into consideration these three things. But if your lordship kindly see, if I say that this is an award, if I say, kindly turn to, my lord, the award part. See, this is my lord, form 13A. Kindly turn to form 13A. And side by side, my lord, kindly turn, but kindly, my lord, have a look at the, my lord, the section 11, the three conditions. Kindly side by side. Now kindly turn to the name at serial number 181. My name is appearing. The name of my mother. Then the award, the alleged award sheet. Although this is not the award, it's a 2002 and 2003. But kindly see 181. Ramdulari Joswal. The name of my mother. Now see, the plot number is there. And, my lord, the area is there. My share has been mentioned. Land value has been mentioned. So these are the three conditions has been fulfilled. Then where from they got it? If I don't submit my documents to their satisfaction. Now, if I submitted the documents to the satisfaction, then how, my lord, this can be said? I put it into myself as not verified. My document has been verified. That's why apportion has been done in my favor. Award has been declared in my favor. And my share has been reflecting from here. And even then they are saying they are not verified. What has not been verified? I put it to myself. If it is not verified, no award can be made in my name. Can't be. If how an award can be made and money can be deposited in respect of a person who has not been verified.
Yes.
So therefore, my lord, my reciprocal submission before your lordship will be this, my lord, that this declaration was made, as I find from the documents, declaration made on 29th, my lord, if I am not wrong, this declaration was made on 5th of June 2002. 5th of May 2002. And that is at page 11 of the state affidavit. So award should have been made by 4th of June 2002, 2004. Within
2 years from the date of
declaration.
section 6.
Section 6. That is, my lord, section 11 capital A. May I read out for your lordship once
All
again?
right. All right. Section 6, 7, yes. 5th June.
Now, therefore, my lord, from the documents to produce before your lordship, it will be evident that no declaration has been made, no award has been made pertaining to a proceeding bearing case number 4/7, 2000-2001. Whatever document they have produced by way of an affidavit or by way of inspection, it is not the case where in which declaration section 4 was made and section followed by section 6. And therefore, my lord, as of today, no award has been declared. And moreover, my lord, I categorically said that I am in possession and why I am in support of my document. By way of a reply, the electricity bill at page 6. A reply to my at page 6. Your lordship will find Amdurali Jaswal, the deceased mother of my petitioner before your lordship. And meter reading date is 25th of 11, 2023.
Where is the electricity bill?
That is at
Yes.
page 7, 6 and 7. In my statement, I have said so. Electricity
6.
and 7.
What is the date of the reply? 17th. 17th August.
6th day of August. Date of reply is 6th day of August. Affirm date.
Which have been replied by and we have. There is no annexure. Who has been? Pradeep Jaiswal.
Pradeep Jaswal. This is paragraph 11. I have said regarding the lapsation of the proceeding. Paragraph 11. Paragraph 11, page
Yes,
5.
6. Yes.
Paragraph page 5. I have stated, my lord, the proceeding has been lapsed. And no award has been declared in respect of the, my lord, the plot number 3467 in Mouja Gopalpur.
Yes.
In this case, my lord, there is no any dispute of notice. Section 17, 4 and 17.
Hmm.
That is in paragraph,
4 and 6.
yes, my lord.
Yes,
4 and 6, there is no dispute. And there, my lord, in the petition, my lord, it is admitted petition.
Mhm.
That paragraph 3, my lord, then 13 May in connection with the aforesaid proceeding, a notification under section 4 of the ARTO, to LA case number 2000 and 2001. Dated ARTO and ARTO under section 4 of the Acquisition Act. That vast area of land of Raigach is likely to be needed for the purpose of the new township project for the operation of the ARTO. And the provision of section 17 of the Land Act published in Calcutta, 1925. And my lord, that admitted position, he also, my lord, my learned friend also, annex that notification, and in that notification, my lord, that is the plot number, that is page 18 of the petition, my lord. If you also will see,
Yes.
petition, my lord, that is the plot number 3467 is the Mauja Gopal. That is very dispute. And my lord, in 6, my lord, after that, my lord, if your lordship will see the page 19, my lord, there is a notification, my lord, that is also the Gopal, that there is no dispute, my lord, after section 6, my lord. That is the advocate position. You know, my lord. That up to that part, my lord, there is no dispute. Only dispute, my lord, one thing, my lord, my learned friend take that Raigach is in place of the Gopalpur, Raigach is there. If that is so, my lord, that is a mistake. My lord, original notification is that is Gopal. That is, and now, my lord, the paragraph 5 of the writ petition, my lord. It is admitted also position, my lord, not everything admitted, but that on or about 12th August 2002, the petitioner was served a notification under section 3(4) of section 9. Land Acquisition Act at present issued by the collector. That is also, that is 9(3) and 4, my lord, 9(3) and 9(3)(4). Also, that is the admitted position that they received the notice, and being the respondent number herein, whereby and whereunder the petitioner has to appear before the respondent number 23rd August 2002 to state the petition and nature of interest and claim for compensation in respect of the said land, to lodge objection, if any, to the measurement of the measurement in respect of the land made under section 8 of the same. Well, now it will also come. Well, the section 9(4) and 9(8).
Wait. Yes.
Let me permitted to come. 9, notice to person interested. That is notice is, my lord, that is he received the notice. That is now 3 and 4. Now 9 subsection 3, my lord. The collector shall also serve notice to the same effect on the occupied territory of the land, and all such person known or believed to be interested therein, or to be entitled to act for person so interested as reside or have organized or have agent authorized to receive service of that matter with the revenue in the land institute. In case any person so interested resides elsewhere and has not any reason, but that portion, my lord, I may not want to hear. As because he, my lord, admits that notice was served. And section 8, my lord, land to be marked out and measured and planned. Now the collector shall thereafter cause the land unless it has been already marked out under section 4 to be marked out. He shall also cause it to be measured. If no plan has been made thereof, a plan to be made of the same. My lord, in paragraph 5, my lord, he admits that there is no any dispute that he received the notice, and my lord, the measurement was did. My lord, if your lordship will come, the ability display of my that part is very clearly my lord stated, my lord. That is, my lord, paragraph 7. I deny and dispute the allegation as made in sub-paragraph and the secretary that notice of section 9 and 9(4) of the Alien Act was issued in this category. Say that terms of the said petition have the mother of us, namely Srimati Ramkulali Joshua, this is duly appeared on Apple. Before the collector, being the respondent number 2 hearing, and produced all the relevant document as was asked for in support of her right, title, and interest in respect of the land in question and the satisfaction of the said respondent. I further say that the allegation pertaining to but the title could not be verified to the petitioner is misleading and contrary to the record, in as much as it has not been stated as to why title could not be verified, despite of the fact that it has been stated in the petition that they are mother appeared before the respondent number 2 here and produced all the relevant documents in support of our claim. Further, the allegation pertaining to declaration of award, whatever that misleading and as such intentionally, deliberately, deponent did not disclose the date of passing of the award. No document in support of declaration of award has been annexed to this. My lord, that is it is my lord. He produced all the documents. Now, my lord, verified and non-verified. My lord, verified means, my lord, if all the documents are produced by the parties, my lord, if we satisfied, then, my lord, it will be verified. And if we are not satisfied of those documents, it is not possible to us for the satisfaction of us that he is the owner of the land, then, my lord, it is non-verified. That is our term, that is NV, verified and non-verified. And it was specifically, so there is no any dispute that he produced all the documents, but those documents was not, my lord, satisfied us, our officers, to be as he is the owner of the land. That is for that reason, my lord, it is not verified. And it is also, my lord, it is very clearly stated that he was present on that day before the collector. There is no any dispute. My lord, he in paragraph 4, that is in ability reply, he, my lord, specifically stated that he was before the collector with all documents. That he was on that day and he was present on the collector's service. There is no any dispute. Now, my lord, I am coming before your lordship that
Mr. Pan, substitution has been made. When? Just a minute. When?
And it was allowed by Justice Claudia. Over there.
And one.
May I check the record that I can satisfy you? I have
reply the reply by the representatives of the Pradeep Kumar Joshua.
আমরা সারিয়ে করেছি।
Yes.
My lord, in paragraph 6, my lord, of the petition, he also stated that produced all the relevant document. He was present on the before the collector. There is no any dispute. There is no any dispute that he was present before the collector on that day. And my lord, now, my lord, I am coming. Now, only, my lord, the date
No,
of
he has raised a issue that if an award is declared under 12, it is a final award. So the verification, whatever, has to be made prior to section 12. How the award after declaration, it becomes non-verified.
That is, my lord, if you are come. That is, he was with our officer on that day, my lord. That is, he produced all the document, and all the document is not, my lord. We are not satisfied for that reason. That was
No, while you were issuing notice under section 9, you're asking him to produce the documents.
yes, my lord. For
After 9, there is a declaration of the award.
yes, my lord. After that, my lord, we declared the award. That is,
Now, 7, except clerical mistakes, you cannot verify any other thing. So, how this award becomes? Okay.
now, my lord, that it was on that day, my lord. We are not satisfied about his declaration or anything else, my lord. Now, my lord, we, as per your lordship directions, my lord, we produced all the documents. And my lord, if there is any ambiguity or anything else, my lord, entire order sheet was given, my lord, copy Xerox and given to my learned friend. And also he, my lord, inquired, scrutinized all our documents.
এই অর্ডারটা
Yes.
Now, my lord, now the problem starts, my lord. That is from the date of award. From the order sheet, my lord, it is not, we suppress anything or anything else, my lord. We produce all the documents and all the order sheet is there, my lord. Activity of the order sheet, that is, my lord, due to our mistake or anything else, my lord. If your lordship will see entire order sheet, my lord, case number, that is the, my learned friend took that point, that case number. In all the, from the start, my lord, case number LA 4/7, 2000 and 2000. এক মিনিট দাঁড়াও, তাহলে আমাকে বলতে দাও, তোমার সময় তো আমি কিছু বলি। My lord, if your lordship will see, there is no any, that there is the case number, my lord, LA 4/7. Now, my lord, my learned friend said there is no any declaration of award. This order sheet, my lord, has come at the instance of my learned friend, my lord. So what I never produced to rectify it or anything else, my lord. So it is admitted position that entire order sheet, my lord, according as per request of that per proposal and as per order of the Honorable High Court, my lord, I produced all the document. There is no any, my lord, in that award, my lord, in that thing, my lord, there is a specific page 11. If your lordship will see, that is award has been declared. My lord, page 11, my lord, if your lordship will see, page 11.
Yes.
How award declared? My lord, that is 17/2/03. That is award has been declared. Specific date, my lord. And estimated, my lord, what is the estimated amount or total amount? That is 1 crore 9,84,000. Verified. Those persons appear before us, my lord, they are verified. My lord, their titles and other things, as my lord, as we satisfied. My lord, that is 64,90,000. And on that day, my lord, if your lordship pays 12, my lord, on that day, my lord, payment made over payment made now the position, and on that day, my lord, that is page 12, your lordship will see payment made, my lord. On that day, everybody is there. On that day, all the awardees, all the person who are giving notice under section 19, and that is 9 subsection 3 and subsection 4. My lord, all the person was there. As for that is, my lord, all the payment was made. Those who was not verified, they are also present on that day. My lord, this proves that payment made on 17/2/03. And possession, my lord, if your right side, if your lordship will see, possession handed over to the RB's representative, Mr. Dilip Kumar Mekar, Surveyor, Housing Department, for an area of Ato. On, my lord, 21 February. Now, my lord, if your lordship will come, page, my lord, section 16. Power to take possession. When the collector has made an award, before that, my lord, under section 11, my lord, page section 16, power to take possession. When we are entitled to get to take the possession, to hand it over to same the recurring body. When the collector has made an award under section 11, he may take possession of the land. Made an award under section 11, he may take possession of the land, which shall thereupon free from all encumbrances. Absolutely in the free from all. That is 17. Declared the award. After that, according to the provision, 16, we take the position. And my lord, if you are also will see, our possession certificate is also to that effect, my lord. There is no any possession certificate is there, my lord, in the and my lord, if your lordship will come to our evidence in opposition, page 24.
No, where is the possession certificate?
Yes,
Yes.
page 24 of our evidence in opposition. Page 24, my lord. Given that I have these dates, that is 21st April, this is the permission of the
Yes.
so my lord, possession is also task, my lord. There is my lord dispute about that one. Now, my lord, my learned friend said that the is to be given. Now your lordship will come again, page 12. Hey, my lord, that is the section 12.
Yes.
My lord 12, such award shall be filed in the collector office and shall, except as hereinafter provided, be final and conclusive evidence as between the collector, my lord, now, and the person interested. All the person is there, my lord, and the person interested, whether they have respectively appeared before the collector or not, of the true area and value of the land as the apportionment of compensation among the person interested. All the person is there. For that is, my lord, we verified and not verified, here is separate. And my lord, total estimated value is 1 crore. And from that, my lord, there is something that is 64,000, another that is we paid on that day, and other that not verified amount. Those were not satisfied. Our officer was not satisfied that their title is correct. For that is, my lord, it is not our duty, my lord. It is not, it is, there is no any provision that our officer can testify the title of the search. For that reason, my lord, it is a provision to send the matter before the LA tribunal judge, and he will decide who is the actual owner of the land. For that reason, my lord, for our clarification, verified, my lord, we are satisfied about that system. And non-verified means, my lord, we are not satisfied. For that, we will send the matter to the. For that reason, my lord, that is the money will be sent to the that is the LA collector's land tribunal. That is also, my lord, in the ATO. That is also, my lord, in our.
And what does 31 say so? Section 31. When can it be sent to the court?
Yes, my lord.
The title.
My lord, 31.
Yes, yes.
On making an award under section 11, the collector shall tender payment of the compensation awarded by him to the person interested entitled thereto according to the award, and shall pay it to them unless prevented by some. My lord, on that day, all the person is there. Those who are, my lord, we are satisfied about their title, the same. Another person that is awarded to the person interested entitled thereto according to the award, and shall pay it to them, my lord, now, unless prevented by someone or more of the contingencies mentioned in the next subsection. That is, if they shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title, that is our. That if there be no any dispute as to the title to receive the compensation, or as to the apportionment of it, collector deposit the amount to the compensation in the court with the reference under section 18 to submit. That is reference court, my lord, submitted the reference to the LA tribunal. We must deposit the amount to that time. So we must deposit the amount. If he wants to get that, he go there and take the money on producing on, my lord, after submission all his documents and other things is there. This is the, my lord, facts and figures of the. My lord, now, my lord, it is very clear that we have declared the award. And my lord, everybody, in the presence of everybody, that was declared and money was paid. And those who are not entitled, we are not satisfied about the title, those money were separated and segregated and sent to the LA court, my lord, that is the tribunal, according to the provision of 31. So, my lord, and
Yes.
my lord, from the, it is very clear from this, my lord, that is from the petition, that is the writ petition and our, my lord, It's very clear, and from the my lord, the entire records, it is very clear that my lord, section, it is a admitted position. Then there is a notification of the 17(4), my lord, and that is the notification under section 6 according to the 17(4), my lord. That is, and after that, my lord, only dispute, my learned friend took that dispute, that we are not declaring the award. But according to this, my lord, I can prove, my lord, I prove, my lord, that the declaration, that is the award, was there, and my lord, that was in the presence of all the parties and with the verified and non-verified person. That is, verified means, my lord, those person who, my lord, who can produce all the records and we satisfied about their title and other things, my lord. We have given them money and other person was not. So there is any provision of section 12. There is a provision of another notice to the person. If they are present, according to 12, my lord, there is a very clear provision. Such awards shall be filed in the collector office, shall accept as in hereafter provided the final and conclusive evidence as between the collector and the person interested. Whether they have respectively appeared before the collector or not, or of the two area, the value of the land, the apportionment of the compensation among the person interested. Selector shall give immediate notice to the award of such person interested are not present. Those who are not present on that day, we must give them notice. That here is all the person is there, and we are satisfied about them. And after that, we paid some money, and those person we are not satisfied about their title. My lord, those money was there to the according to the provision of section 31. So there is any ambiguity, or there is any, and my lord, section, my lord, according
So
to
the petitioner was present.
yes, my lord, everybody is present. That is
Incorrect statement. I am not present. But at the time of declaration of the award, I was not present, and no record has been produced that everybody was present. Not even the affidavit.
my lord, your lordship will see that on that day, that money was paid. So everybody was there. And in the provision, my lord, if your lordship will see the provision, well, such award shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence as between the collector and the person interested. Whether they have respectively appeared before the collector or not. There is a provision that there is a, my lord, they can appear before the office. Otherwise, my lord, how the money was paid to them on the same day? Money was paid on the same day. That is, my lord, if your lordship 12 payment made. And now, my lord,
Just
and now, my lord,
yes.
now, my lord.
30.
Collector,
Section 13.
yes, my lord. correction of clerical errors.
Yes.
Collector may at any time but not later than 6 months from the date of the award. That there is a restriction. There is a restriction. My learned friend can take that point, that there is a restriction. After that, he has not any authority. But now, or where he has been required under section 18 to make a reference to the court, before the making of such reference, now, my lord, the limitation is, my lord, is twisted. Before the making of such reference, 6 months, if there is any reference. If there is not any reference, then that part, that is 6 months, is not our binding force, my lord. That is, by order, correct any clerical, arithmetical mistake of the award or errors arising therein, either on his own motion or the application of any person interested on local authority. My lord, only for that reason, that is a mistake or error, is not. Say, my lord, I am the award. How I now die, my lord, after my death, my lord, my heirs will not get the money. If that is the, my lord, that is, there is no any provision to correct or change the award, then, my lord, my heirs never get the money. For that reason, my lord, that is a arithmetical mistake or any award arising either on his own motion or application of any person interested or local authority. Any person interested, that is the person died, I died, after the death of myself, that is my heirs will get that money. For that reason, my lord, application of any person or local authority. That is now, my lord, our entire sheet is there, my lord. That is the everything that some person, my lord, is died and anything else, my lord. That is my learned friend, my lord, wanted to show. That is that is, for that is, my lord, page 15, my lord, showing the rectification of the post award verification is enclosed here according to the award and other things, my lord. Everything is there, my lord. And after that, my lord, that is in the last part, my lord, that is my learned friend showed, that is paragraph 18, my lord. That is verification of award is postdated has been done by LD and Ekebos, and the schedule and reflected after verification of put up below the kind petition of Ato 1223 and Ato, and amount of rupees Ato has been prepared by the Stenelo. The same has been checked, verified. Now the award amounting rupees Ato to Ato from 12 and 13 is placed before the kind applicable of the secret collector. Verified amount of Ato is prepared and placed before the approval of the verification award. That is page 19, my lord, after done in the Ato, the verified after verification along with looking at the cross reference of the award of serial number, both the original award and the present revised award. Original award for an amount, original award, that is amount of rupees 1 crore Ato, and the amount of original, that is here is my lord, and 5 crore Ato of the original award amount of rupees Ato requires to be paid to the claimants and other persons interested. Now this amount to be Ato, rupees Ato, now to be excluded from the 12 and apportionment shown in the record. And according to procedure, my lord, we have done everything. So there is many error of the, we have not, my lord, done anything. Excess of the provision of the Act.
No, what about the approval argument with regard to section
Approval, my
11?
lord, your lordship will see in every case, my lord, award has been declared, my lord, that is the everything, page 17, my lord, if your lordship will see, that is the State and Joint Secretary, my lord, will sign in the last portion of the same matter.
So, as per the Land Acquisition Act, who is the collector? The Special Land Acquisition Officer?
No, my lord, that is the collector. My lord, they are now, my lord, everybody is collector according to the provision. Those, my lord, those person who is be entrusted to see this, my lord, that is the do this thing, my lord. They are giving an my lord, there is a
Who is the collector?
power.
Collector. Item is the district includes deputy commissioner or any officer appointed to the functions of item. It's not that district magistrate is the collector. Any officer can be authorized to act as a collector.
Yes, my lord.
So in this case, the approval has been granted by the district magistrate.
Yes, my lord.
Granted,
Uh-huh.
document. No document.
There is a signature of the district magistrate joint secretary below the signature of the special land acquisition officer.
May be approved. May be approved. Kindly see the language. This has not been written approved. May be approved. Not a single document that this has been approved. Language is may be approved.
My lord, it is a procedure, my lord. They first, the officer is, my lord, taking the maybe approved, then, my lord, signed by the district magistrate. So, my lord, approved is there. My lord.
Now, the special land acquisition is acting as a collector in the present case. He is placing for approval by the district magistrate.
After that, my lord, district magistrate, last portion, district magistrate signed, my lord, by president, my lord.
Hmm.
This 10, my lord, may be approved. After that, my lord, in the lower portion, that district magistrate is signed. Then, my lord, declared at 11.
Yes.
But I have my point, and my lord, my lord, Palpur and Raigachi, Raigachi, that is, my lord, there is only one mistake is there, my lord, that is if Gopalpur, we have stated that Raigachi in 3467.
Hmm.
The, it should be Gopalpur. That is according to the 4, 6 and other things, my lord. All the original notification is same, my lord. And most of the awardee, my lord, took the money. And other who are not, we are not satisfied about the same, my lord. That is that money was not paid to them. Their money was deposited, my lord. If they want, my lord, they can take the money at any time before filing an application before the LA court, my lord, in case number, referring the case number, my lord. My lord, so I have not, my lord, listing or anything else, my lord, according to the provision. We are in the all the provision we have complied with, and there is no any, my lord, we violate any provisions. So, my lord, the bid case for the dismissal, and my lord, if he wants, he can take the money from our LA tribunal. My lord may be permitted to. My lord, that any, yes, my lord, any, my lord, my lord, my lord. My lord, those will not, my lord, in our, will apply in our case.
Mr. They have elaborately give the answer in all questions raised by Mr. Pan. Worship, I am raising some points, Worship, which are not related with regard to this land acquisition proceeding of this, that has been specifically
Your
stated by
response
my
number?
learned friend, Worship.
Response number?
Yes, no, 4A, recovering authority. Worship, just take.
Yes.
I am first placing a writ petition. Stop date, Worship, in short, Worship, stop date. When it was initiated and when concluded. So there is a very vital point, Lordship. Worship, page Roman 1, the list of date of the writ petition. On before Lordship, obstacle before everything. Like 2000, no date, nothing, only the year. In connection with the Rajarhat Newtown project, the collector being respondent to initiated a proceeding under Land Acquisition Act 1894 at present repealed case number such and such 201 Lordship. 13/5/2002 in connection with the aforesaid proceeding, a notification bearing number such and such LA 4/7 of 2001 bearing number such and such dated 24th April 2002 under section 4 of the Land Acquisition Act at present repealed was published whereby and whereunder it was notified that the said land, including the vast area of land, Lordship, very vital, Lordship, vast area of land, more than 20 kilometer, Lordship, in Newtown nowadays, within Mauja Raigachi, is likely to be needed for the purpose of Rajarhat Newtown project. In the said notification, it was also mentioned that the respondent has also invoked the provision under section 17 of the Land Acquisition Act 1894 at present repealed, and the said notification was published in the Calcutta Gazette, May 13, 2002. Lordship, that is one parameter which has been complied with. It's the initial notification that must be complied in the newspaper, in the conspicuous places, as well as in the Gazette notification. Subsequently, further notification bearing number 24, number North 24 Parganas, 93 LA 4/7, 2001 NTP, dated 5th June 2000, under section 6, that is the declaration, Lordship, at present repealed. Next, Lordship, 12/8/2002, the petitioner was served the notice such and such, and under section 9 of the Act, Lordship, that is also, Lordship, complied with. Next, Lordship, 23/8/2002. In Land Acquisition Act, there is the only provision where the landowner, land loser,
got one opportunity to appear before the authority, that's under section 9. Barring that, Lordship, there is no such provision to appear or ask for any notification because all such thing has already been specified and declared and published in different area, different way, 3 mode of ways. In 23rd August 2020, 220, in terms of the notification dated 9th August 2002, bearing number A4, petitioner appeared on 23rd of August 2002 before the LA collector and being the response number 2 and produce all relevant documents such and such. On 1st January 2014, let's see, thereafter nothing. Thereafter nothing, let's see. What happened thereafter? After 12 years, Lordship, he jumped over the issue, Lordship. 2014, the act being repealed, act, so they came forward in 2015, that is 16 December 2015, petitioner being offense such and such, being number such, when the first time the petitioner was informed by the office of the respondent, the award has been declared and in respect of the land in connection with the said proceeding, Lordship. Admitted position, everything, Lordship. Sub-notice, the compliance of all provision since from section 4, section 6, section 9, award everything, Lordship. And Lordship, after 2002, section 9, Lordship, he did not appear, he did not respond to all such things, Lordship. And thereafter, Lordship, possession was taken, Lordship. That is a very vital. I am relying upon the affidavit of the learned additional government pleader, being the LA collector. Lordship, he has placed this document regarding the possession certificate, page 24, annexure R4 of the affidavit in opposition of the LA collector. That is, the possession was taken on 2021st February 2003. Lordship, my result submission, when he has approached this court, after 13 years, he approached the court. My result submission, the writ petition is a stale proceeding. It's a stale proceeding. You have no authority to raise such point after such belated stage. And we have been told severally by our apex court, since from our high court, Lordship, that is a moot question. That is a moot question, not with regard to the so many things, legal acquisition.
Possession of the land taken over on which date? On which possession?
Possession was taken on Lordship, I'm sorry. 21st February 2003 from annexure P4 R4. And from the affidavit, writ petition affirmed on February 2016, affirmed. Date of affirmation. Now, what is their prayer? They are claiming that the provision of the act has not been followed, and that is why it is liable to be crossed and the land may be derecouped. So I'm placing the prayer, page 13 of the writ petition.
Yes.
Yes. Lordship, paragraph 26, I'm reading. In the circumstances, most humbly pray that your Lordship may graciously please to issue a writ in the nature mandamus commanding the respondent to issue the formal order of de-requisition in respect of the land, enabling the petitioner to use the said land of her own choice. A writ in the nature of Sasorai, calling upon the such and such, rule nice and order direction, issue of order as on de-requisition, such as identity such and such. That is their case. According to the writ petitioner, provision of the act has not been followed. So now it is lapsed and the land may be de-requisition and handed over to them. About the self-same issue, Lordship, recently our High Court passed an order which went to the division bench as well as to the apex court. Lordship, all such things, these points have been elaborately discussed and rejected the writ petition and dismissed the writ petition, and SLP was summarily dismissed. Lordship. But one thing, Lordship, I'm very sorry.
Let my land will be handed over to all the judges.
Lordship, and now, Lordship, Lordship, I'm relying, Lordship, relying upon this in particular 2020, volume 8.
What is the paragraphs you are relying?
Yes, let me, I'm not disturbing you, please. Let me complete. The parent judgment is Indo Development Corporation.
No, what is the citation?
Citation I'm reading.
2020?
2020, volume 8, SCC is big judgment. Lordship. Start from it starts from 129 and ended on 394. Relying the amount of this judgment, our High Court, Honorable Justice Shogoto Bhattacharya, same matter, Lordship, dismiss the writ application. Bholanath Kole versus. I am handing over the unreported judgment of our High Court division bench as well as apex court to your Lordship, because my clerk have not come due to his illness, Lordship. I could not bring all such 5 Lordships. Just to assist your Lordship only, I appeared before your Lordship for placing all such things, Lordship. I am placing the book also, Lordship, if required, Lordship. And in that thing, Lordship, I am relevant paragraph, Lordship, I am reading. One paragraph, I am just citing, reading, Lordship.
Paragraph number?
Paragraph number 129, Lordship. I'm placing the book, Lordship, here to your Lordship. Data, the 2020, volume 8, SCC. I'm placing this judgment, so I have on copy, Lordship. That may be kept with your Lordship. Lordship, thereafter, I'll take back, Lordship, in course of time. Eight IPS. This matter of acquisition, this particular
Yes.
this court has thrown upon.
Let me know the paragraphs.
I'm placing. I'm
Paragraph, let me
the
know
book.
paragraph.
The book is the book is
This is the Malad 365 pages judgment. He is relying. Let me place at least the paragraph.
I am relying the entire judgment because Lordship, 381 number of judgment have been cited in this case. It is a full bench judgment of Honorable Supreme Court Lordship, and this was decided in 2020, volume 8, reported in volume 2020, volume 8, page 129 onwards, Lordship. So that is why, Lordship, it is not, my learned friend is absolutely correct. It is not my duty to place in such way before your Lordship. I am placing the book, Lordship. If another opportunity may give him, Lordship, for 10 minutes, I will place all such things for your Lordship satisfaction.
Monday দেখো তো
And Lordship,
Monday থেকে Monday
my Lordship, no,
conclude on the next.
Lordship, my clerk will not appear. Come, Lordship, my junior is not there, Lordship, that the reason.
Sir, he has concluded,
when-
the state
when
has
is the
concluded, now you conclude your argument. Enough of time has been given.
Lordship, I'm not, on Wednesday, Lordship, on Wednesday only.
Wednesday থাকো, Wednesday conclude করবো। Wednesday তে দেখে নাও কত বলছে।
Wednesday.
আমরা সেই তারপর আরো শুধু বললো দেখা যাবে যে উনি এলেন না, উনি একটা কিছু করে বসলেন। হ্যাঁ, ওটা কি টপ টপ কিছু করেছি Wednesday? কত তারিখ Wednesday?
আমার কাছে রিপোর্টের জাজমেন্ট
13 তারিখ?
এটা অন্য জিনিস, এটা
দেখা তো
এই দেখো
কিন্তু ওইটা নেই তো।
আমি এসব করি না, যদি জাজমেন্ট থাকে তো বলে দেবো।
8 তারিখ না ওটা? Wednesday 8 তারিখ? ক্যালেন্ডার একটা নেই কেন? Wednesday তে রেখে দাও, ওটা যদি এগিয়ে তো অনেক সময় করতে হবে, যদি অ্যাডজার্নমেন্ট ডানা হয়ে যায় তাহলে Wednesday রেখে দাও, অনেকটা শুনে নিয়েছি। কখনো করলে তো এটা পৌঁছে দেবো। ওগুলো কতগুলো আছে? ওইটার পরেই রেখে দিয়ে আছে, এটা সিজনই আসাই তো, এটা স্পেশালি আসাই। এটা উপরে থাক।
I am also filing the division bench judgment.
আসুন,
I'll hand over it to
346 প্যারা
346
হলো, আর মিস্টার অমিত কুমার পান, an advocate for the petitioner who concludes his argument. Mr. Chondi Charan De, an additional government pleader appearing for state respondents, also concludes his argument. Mr. And soon an advocate, ইনি হচ্ছেন মিস্টার দেবব্রত ব্যানার্জি না? Learned advocate appearing for added respondent number 4 capital A, 4A, capital 4A, seeks some accommodation to place his points of arguments. Place this matter on 8th January. 8th January.
Much obliged.
When is 8th? Pritam Babu? 8th January.
Could I request my senior friend to hand over me a copy of the judge unreported charge so that I can place my case?
The tailor Sohan. He will get this thing. He's well equipped from his computer lordship. Anyway, lordship, he asked lordship.
How come he know that which judgment you are going to refer on?
Lordship, I'm-
Give
I'm-
a notice so that he can make his reply and conclude his
No, lordship,
replies
I'm
on that.
certainly-
এটা দিয়ে দিন।
Yes.
Mr. Pan, you make a photocopy of the judgment you have referred.
Lord, I will photocopy. And I
And hand it.
will rely, my lord, since my learned friend raised this point, my lord, I will rely other judgment also, my lord, I will hand up the copy to you.
রেখে দিয়েছে আপনার? না। এখানে আছে তো? আপনার কাছে আছে? Much obliged, lordship.
Item number 2,
Correct, I am for the proceeding matter.
Yes, Sudha.
On the last occasion, my learned friend hasn't concluded his submission. Let him
এটা নোট ছিল। Yes.
Make a short service.
এটা নিয়ে নিন।
get a copy.
Question on the last occasion, I have tried to demonstrate before the honorable court that how they have tried to take advantage of the litigation. When the land was completely gone to someone's hand from the state government to us, then he tried to recover and then he's tried to file the suit. Now, Lordship, the two suits which I have mentioned, but the copy of the suits was not with me. Lordship indicated that. In that case, Lordship, kindly look into the suited copy. Suited copy. Lordship, these two suits, as recent as 2024, they are.
One before the civil judge junior division, another before senior division.
If your Lordship kindly takes a suit number 56, kindly see the prayer.
Yes.
Page 11. They have asked for it. If your Lordship is looking into title suit number 56. Prayer is decree declaring that the plaintiffs are the actual owners of the land property as mentioned in the schedule below, as per letter dated such and such, issued by Obkar Colliery. Lordship, I have shown that those two collieries, it was a colliery land, so then 1973 Act, it based on the government and then government to Coal India to me. That is how it was for. Now, Lordship, now today he is making a avowment before the court that a prayer declaratory nature
that he is the owner to be declared. So now, if this suit which he has filed, declaration, is contesting in the court below, Lordship, I put this question to myself: can this writ is maintained? Because he himself raised it with regard to the
Yes.
title of the. Now, Lordship, kindly turn to the who are the party made. Page 1. Lordship, at best, the juristic person should have been a party, to my understanding. Because it is never a case that my chairman and general manager is going to the land and grabbing their property. So the juristic person, at best, what I'm saying is, he either commits a mistake or he calculatedly makes a mistake. Can a declaratory prayer against a particular person be entertained by any court? So, Lordship, kindly see, and then kindly see. Now, the pro forma defendant is proprietor of some brick company. Two brick companies are being made a proprietor. If at all someone is in possession except my client, is those two persons. So they should have been not pro forma, they should have been made a proper party. Suppose he is not talking about title. He is just talking about possession. I was in possession, so someone else has come in possession. So he has to get back that possession. So if he is calling upon a title, then Lordship, my client is not a party here. Only the chairman and the general manager and the agent is a party. Now, Lordship, kindly turn to again the prayer portion. Schedule below as per letter issued by the Apkar Colliery. As the said Apkar Colliery over the land and mentioned below, along with possession and all kind of enjoyment right to his grandson by issuing letter this 1952, and the principal defendant has no right to capture the suit property for mining operation.
Yes.
So he is enforcing a document of 1952. If he is aware of this, now Lordship, kindly see who has affirmed this. Ashutosh Mondo. Now, Lordship, kindly see who has filed this suit. I read.
Deepdas.
Lordship has got. So, Lordship, then Ashutosh Mondal, Tulsi Mondal, who are the son of late Thakurdas. Lordship has got. Now, Lordship, kindly turn to the writ. The property belongs to paragraph 2 of the writ.
Paragraph?
Lordship, kindly see
Paragraph?
para 2. Para 2. Your petitioner are the legal heirs and the property of Leb Mahadev Ghosh, sole proprietor, absolute owner and possession of the scheduled property in such and such, Paschim Bardhaman, Mauja such and such, jail number such and such. Plot number, Lordship, kindly see the plot numbers. Lordship has seen the plot numbers. Lordship will find 301, 302,
300.
303. Out of this,
So 301 is not there.
no, Lordship, none of this is there, except
Except 302.
302, none is there. None of this. Except 302, none is there. Now, Lordship, kindly turn to the schedule of the suit.
Yes.
Lordship, kindly come to the schedule. Now, Lordship, kindly see the moja is same.
Yes.
Now, if I want to believe the client, if I want to believe their story of the writ petition, then Lordship, in a moja, few plots belong to A, few plots belong to B. And we have acquired plot wise. Lordship, we are not the builders or the promoters that we will take a plot wise. We take moja after moja, Lordship. It's a mining company. So, Lordship, the entire moja is under requisition. So, what they have done, this HON'BLE family, they divide themselves. Someone files a suit, someone files a writ. And the story is, Lordship, Opkar Koli. All of them got from the Opkar. So, how I am binding those two persons together? Not by title, merely because title is common, so both are same. I'm not saying. I'm saying the right of inheritance or right of acquisition of title is from the Opkar Koli. Let me believe him that this Mandal group and the writ petitioner Mandal group is different. Even if so there is a, what I'm saying is only another group of person on the same moja. So the moja is common and the title giver is common. Opkar Koli. And then rest of the two parties are saying this much land is mine and this much land is mine. So, Lordship, the dark number also there. Now, Lordship, if at all from the CS record, then RS record, then LR record, pre-independence, just after independence, and in the present, Lordship will not file a single copy of Khajna by any of the mandals. They are only relying on unregistered document and letters between him and Opkar. Now, whether Opkar Kalihari was existing, whether the seal was there, whether that person was there in 1952 document, he is saying based on that I am saying. So, Lordship, what I am trying to demonstrate before your Lordship is, if 2024 suit filed based on a 1952, and which shows that I was in possession for more than 12 years.
Yes.
Lordship, he lost his all right. I'm trying to show his right on a property from a different angle. If I'm in possession for more than 12 years, whether I should believe his litigations or not, whether the acquisition of the title from Opkar Kolihari can be believed or not. His story is surrounding around the fact that the Opkar Kolihari has given him the right title. So I'm trying to show that they are the rival claim, rival people, merely similar in the title, but similar in the surname, So in the surname they are similar, but does not mean that they are same, but then everyone is saying from Aapka they have. So this is one plain analysis. Lordship, kindly take up the next plain, Lordship. 741.
Same. Yes.
Lordship will find in 741, Tulsi Mondol is common with the first suit. And Shivdas Mondol, plaintiff number 4, is the writ petitioner before you.
Yes.
Now, Lordship, kindly see, he filed the writ in 2023. He filed the suit in 2024. Now, Lordship, kindly come to the prayer.
Yes.
Lordship, kindly compare this prayer with the earlier suit, Lordship. Lordship, I will try to compare line by line, including the typographical error. In the second line, Lordship will find there is a typographical error which is marked X. And in the second suit is the marks X. So, Lordship, from the error, I can always say this all person must have gone to a same person to prepare the same suit.
Yes.
Now, Lordship, kindly see the pagination. The prayer comes in page 11.
Yes.
And the symbol used before the pagination is also same. That means the same typewriter has been.
Yes.
Lordship has got it. Now, Lordship, kindly come to the schedule of that.
Yes.
Now, Lordship will find 206, 208, 209. Lordship got it? 206, 208, 209.
Yes.
2012, 2011, 2013, 237, 239, 240, 311, 312, 380. Lordship has got it? Now kindly come to the page 4 of the writ petition, para 2. Now Lordship will find the same dag numbers. So Lordship, one set of person is filing a suit against my office bearer, not against the jurisdiction. Now the second set of person also files against the office bearer of mine. And in the second suit, Lordship, the land in question is same. So, Lordship, first he filed a suit in 2019, a writ in 2019, then the second writ in 2023, then a suit in 2024, and everywhere he is getting the property from the owner. So, Lordship, this is the nature and character of this petitioner before your Lordship. Now, Lordship, kindly see. The prayer of the writ petition. Now, one by one, I will put a question to myself, whether these prayers are existing today or not, can exist or not. Lordship, kindly see the prayer A. Respondent to stop the process of acquisition. Respondent to take necessary steps to stop the process of acquisition. B. Without due process. Directing the respondent to produce all record related to this. Then Lordship, restraining the respondent. F. Restraining enter into the land, Lordship, this. And then entry mark. So, Lordship, this writ petition is again a plea before your Lordship to set the court black, because the acquisition has already been taken place. He is aware of. He could not get his mutation. He has gone to LRTT. Lordship, I have shown that documents. So, a person who is quite aware, a vigilant litigant, he knows every right of his.
Yes.
So then he chose to make this prayer. And today he is pursuing the writ petition before your Lordship. He has the guts to pursue this writ petition before your Lordship, stating that now you stall that process. That means he is asking for a status quo ante. And in that case, status quo ante cannot be granted because it is already done. It can only be set aside. And if it is to be set aside, then it cannot be by this court. It has to be by a different forum. So they knew it. They know the law. So they have come before the Lordship. So this is the factual matrix of this case, Lordship. Lordship, now kindly take up my supplementary, my report which I filed.
Report of opposition.
Lordship, I have filed a report, Lordship. Affidavit in opposition.
Tausif Sheikh.
Yes, yes, Lordship. Filed affidavit. Lordship says we have found.
Yes.
Now, Lordship, kindly come to page 114.
Yes.
Lordship, kindly see 16/5/2018 order at the bottom. The case is taken up for hearing. Shivdas, Mondol and others. The applicant appeared and filed Hajira. So, Lordship, this 16/5/2000 order is at least known to him. So then the order says that benefit cannot be given. It is already vested. Those lines I have placed, Lordship. Then, Lordship, the final order is at 116. Lordship, then. PLR order concludes at 116, Lordship, where it says that undersigned has gone along through the order respect of this, wherein the state government has not been party. So this is, I have placed on the last. What I wanted to show from this order is, he participated in the proceedings where he knew that BLRO has rejected his pair. So this order of 2018 is not under challenge anywhere before your Lordship.
So vesting has reached finality.
Vesting reached finality. Then Lordship, he said, no, vesting probably was incorrect. My name should be there. So he gone to Calcutta High Court. Calcutta High Court given him a liberty. All the time we said, consideration order, all right, we do not oppose. So Lordship, he took that opportunity. Then he gone to BLRO. Then he was rejected. Then he has gone to LRTT. From LRTT again he remanded back to BLRO. BLRO has twice rejected him, saying that no, everything is done. So now he was quite aware of that the vesting has completed, Lordship. So now compare this order and his appearance with the prayer made today. So when he appeared himself before the PLRO authority, he knew that his prayer has not been done. So can he come back to this court and say, now you stall the acquisition process? He knew that acquisition is over. His mutation is rejected.
Yes.
So I put this question, how skeptical a man can be to draft this prayer? So he has come to the court of equity with at most unclean hand.
Yes.
So, Lordship, that means the prayer which he has formulated today, he can argue that prayer can be molded. Prayer is no matter. Prayer can be molded. So, anticipating that in the reply he might come that prayer can be molded, I am saying that it cannot be molded in this case because you have not thrown any attack or challenge on these proceedings either in the grounds or in the pleadings. Rather, you try to suppress this order. Now, Lordship, I will take your Lordship to the ground or in the pleadings. Count starts at page 11, Lordship, of the writ petition.
Yes.
Now, Lordship, ground number 3. For that, your petitioner states that the petitioner also paid the government khajna in respect of the above land and some of the land recorded in Porcha in name of the petitioner's father and other legal heirs. And an application is pending before Honorable High Court, such and such, such and such, such and such, for correction of it.
This is dismissed for default.
Not willing to process, that's why it is dismissed. We are not willing to process in this matter, that's
So
why.
you are not proceeding.
Yes.
Okay.
The order was there that the petitioner is no more interested in this case, that's why.
That is amounting to that you have withdrawn the writ petition for correction of records.
Unless the leave under Order 22 Rule 1 is granted, withdrawal is also a dismissal. Kindly see CPC, Lordship. If I file a suit and I simply withdraw it, I cannot refile on the same cause of action.
The cause of action is different. It is an open vested and.
Okay, anyway, continue. Yes.
So, Lordship, what I'm saying is, he withdrew that. So, his one of the ground was of 2019 matter. So, this ground goes. See, he took that ground, then that other matter is dismissed. And Lordship, kindly see the any other ground except 8, where he alleged that I'm trying to grab the land. Acquisition without any opportunity of this, is it part of the such and such block start and then the notice respondent wherein not at all interested because the land in question was leased to one private day before the nationalization as such. Now in 8, he admitted that before nationalization, it was leased to a company. It was leased to a mining company. So that his own admission, Lordship. May I read that?
Yes.
The land in question was leased to by one private coal company before the nationalization of. So now, Lordship, I come back and sum up his knowledge. Lordship, he has a knowledge of nationalization. He has a knowledge of the lease out. He has a knowledge of BLRO. He has a knowledge that his writ is pending 2019. So he filed in 2023, then 24, and then again a suit in 2020. So while he was quite aware, nationalization took place, PLRO rejected, then he came back to this court, in a court of equity, and there in a court of law, without making the juristic body as a party.
Yes.
So, Lordship, that can be a mistake, Lordship. Lordship, kindly come to this writ. Lordship, in the writ, they did not forget to make the juristic body as a party as respondent number 3. The same gentleman, Siddharth Mondo, made respondent number 3 here. The juristic body as a party. But in the suit, they forgot. In fact, in the suit, only juristic body could have been party. The
Others will follow, yes. Yes. When?
Lordship, tomorrow I will continue.
On Monday?
Tuesday, Lordship. Tuesday. Any problem?
কবে তো আপনি জানো হচ্ছেন কবে দেবো তো বলো এটা হয়ে এসছে how long you will take this to manage you have almost
I will take not more than 20-25 minutes, Lordship.
I have to submit something more.
হ্যাঁ বুধবার তো ওইটা রাখলেন 10th 9th কর
Bit difficult for me on Monday.
Wednesday তো 8 তারিখ মঙ্গলবার 7th
Or
7th
Lordship,
7th.
উপরে
Let's
হ্যাঁ হ্যাঁ
let's
Lordship will please to
হ্যাঁ স্পেশালি আছে না টপে রাখো এটা yes
no.
heard Mr. Shiv Shankar Banerjee, learned advocate for its respondent numbers due ECL, respondent ECL 2 and 3. Due to paucity of time, the hearing could not be concluded. List this matter on 7th January 2025 under the heading specially assigned at top. গ্রুপ 1 কতগুলো আছে গ্রুপ 1 এ পড়ে not now এটা রাখ
minor
এটা থাকবে চলো
Is to record that copy of the suit filed by them is
copy of title suit number 50 দেখো না 58 of 2024 and 741 of 2024 filed before the Civil Judge Junior Division at Asansol is taken on record as furnished by learned advocate for the respondent number 2 and 3.
56.
56, put a 58 to 56 for it, that's 741. Both of 2024?
Yes.
Okay.
minor dot in the item number 6. I am for the petition and I am learned
On a Monday. It's
Hello,
clear
Dad.
Monday.
Tomorrow onward for 25 5 days I will not be available in the class.
Ask your junior to
Any mentioning irregular bench?
May I have you kindly leave for?
Yeah.
May I have you kind leave for seeking to, my lord, for short service, my lord, of an application for producing additional documents, my lord. My lord, this matter is supposed to be returnable on 8th of this month, my lord. The witness action is to commence, my lord. I
Huh.
need to rely upon certain documents.
What is the date fixed for it?
My lord, it's showing in the last order that the matter to be listed after 3 weeks, my lord. But on the last occasion, it was most probably it was, if I may not be wrong, it was said on 8th January it might be returnable, my lord.
Let the matter come up. No short service for that. On 8th you mention, when the matter will be taken up on 8th.
Kind leave to mention item number 17 in your lordship's list today.
Huh.
Well, this is the application in which Mr. Medora has already made his submissions, and I am to address my lord. Well, I'm told that there is a 330 resolution today also. So therefore, maybe it will not be called on. Millard, I will wait. In case it is called on, Millard, I'll do the matter. Otherwise, Millard, my humble request is kindly have the matter on any day except next Monday. Otherwise, Millard, it will automatically go to Monday's list.
Okay. If you are not present on Monday,
Yeah.
and the matter is taken up, for your convenience, place it on some other day on Monday.
Millard,
Let it be in the list as it is.
I'm mentioning in the Mr. Medora is here. He is agreeable if your lordship gives some date, Millard.
কবে আসতে পারে বলতো? মানডে তো ওরা করতে চাইছে না। মান্থলি লিস্টে গেলে তাহলে হয়ে যাবে। মান্থলি লিস্ট হলো না, একশো পক্ষ হয়ে করে নিয়েছে। ও তাহলে কাজ করো, এটাকে মঙ্গলবার দিন রেখে দাও। অর্ডার কিছু করছি না, করে দেওয়া যাবে? অর্ডার করে দিন। 17 একটা অর্ডার রেকর্ড করতে। On the prayer of learned advocates for both the sides, list the matter on. Tell which date? বলো convenient date একটা বলে দাও। Wednesday? Wednesday commercial, Thursday.
Your Wednesday is commercial. Thursday.
May I permitted to mention item number 19 of your case list. In this matter, your lordship well aware that the IO has circulated the report in terms of your lordship's order.
19.
Present application has been taken out for exception of the report. As the state lawyer has filed the report, the department unable to issue master summons upon the state lawyer. That's why I'm praying leave to issue master summons upon the state lawyer. This is the application for exception of the report.
Well, leave that. Leave, state has appeared in this case.
Yes, Srijoni Mukherjee was appearing in this case.
ঠিক আছে।
Forgetted to mention a matter, Milord. I had mentioned in the morning, your lordship had asked me to come at 2 o'clock. Milord, this is CS number 286 of 1976. This is returnable on the 6th, which is Monday. Milord, we have filed an application which we have numbered as GA number 24 of 2024. Service has been completed in the course of the day. May it be listed on 6th of January with this main CS. Milord, this is for confirmation
Only
of
the fact that, my lord, I appear for the plaintiff. I suddenly cannot stand in the way of him filing an application and it being adjudicated. But the fact is, my lord, I believe he wants to participate in a bid which has been closed on 10th of December and the confirmation is on 6th itself. Whatever the application is, may it not stand in the way of confirmation of the same.
Milord, that perhaps when the application is being considered by your lordship, Milord, whatever falls from your lordship.
Yes, I am for the receiver. Your lordship would recall, Milord, the matter where properties in Rajasthan were being. Lordship will recall that. The entire process of bid has come to a close.
Now he has taken out an application. Let it be listed on 6th. We'll see.
But we have, Milord, given a lot of effort from the receiver's end with police help and things like this so that the things are expedited. I hope it will not prolong the matter. We are for the receivers.
All that I'm praying for today is that this application that we have filed be listed on 6th of January.
6th.
So let it come up before that. In that instance.
Before that, 6th is Monday.
Oh, Monday, 6th. I'm so sorry. 6th is returnable.
Before that, deeply obliged.
I'm sorry.
Yes.
ঠিক আছে এসে যাবে এবার না মানডে তো ওটা আসছেই না আদারের 6 জানুয়ারি ডেট আছে তো হ্যাঁ yes দেখো হ্যাঁ হ্যাঁ
Matter fixed at 2 p.m. Item number 18.
who is on the other side okay এই লেখার এটা কোথায় লিখেছিলাম যে হ্যাঁ ঠিক Depending on holding over since after expiry period of lease, the lesser accepted period especially estate TPA.
Now, Lord, on the last day, I placed a ruling, that is AIR 2005 Supreme Court.
Yes.
Lord, for the proposition that when there is a clause for renewal, and in the event the renewal clause is not exercised, then even after acceptance of the rent, the holding over principle will not apply. When a renewal clause is there, if renewal clause is not there in the lease deed, then the holding over clause will not be applicable. And my lord, because of the language, my lord, which shall come later on with regard to the ruling, the language of section 100, Lord, 15 of the TP Transfer of Property Act itself is clear. Lord, under the Transfer of Property Act, Lordship kindly look to that.
116.
116, my lord. If a lessee or under lessee of property remains in possession thereof after the determination of the lease granted to the lessee, and the lessor or his legal representative accepts rent from the lessee or under lessee, or otherwise assents to his continuing in possession, the lease in the absence of an agreement to the contrary. Lord, I am stressing the point, the Supreme Court judgment, that in the absence of an agreement to the contrary. Lord, Supreme Court judgment says, in the absence of agreement to the contrary, meaning that is in the event renewal clause is there. And in this case, Lord, renewal clause was there. In this case, 2005, volume 5 SCC, page 543. Renewal clause was there. And acceptance of rent was also there. Even then, Supreme Court held that no, because of in the absence of a contract to the contrary, and that was the Lord argument advanced in paragraph 7 of the judgment. An answer is given.
17.
Yes. Paragraph, my lord, 17. Mere acceptance, 18, mere acceptance of rent. We fully agree with the High Court and the First Appellate Court below on the expiry of a period of lease. Mere acceptance of rent for subsequent months in which lessee continued to occupy the lease premises cannot be said to be a conduct signifying assent to the continuation of a lease even after the expiry of the lease period. To the legal notice seeking renewal of lease, the lessor gave no reply. The agreement of renewal contained in clause 7, read with clause 9, required fulfillment of two conditions. First, the exercise of option of renewal by the lessee before expiry of original period of lease, and second, fixation of terms and conditions for the renewal period of the lease by mutual consent. And in the absence thereof, though mediation of local mukhas or panchat of the village through the aforesaid renewal clause 7 and 9 agreement clearly fell within the expression agreement to the contrary. Lord, here I am joining the issue. His defense is that not specifically, his defense is that even after the expiry of the lease, the lessor accepted rent. That is his defense. Lord, specifically the language, legal language holding over was not spoken in the written statement, but it can be understood from the pleading. Court will have to apply the law. Lord, if the materials are supplied in the pleading, and if I may not use the word, legal word, because it is not a magic word, legal words I am not using in the pleading. Lord, that does not mean that the court is powerless to apply the law on the basis of the pleading pleaded by the parties. Therefore, in such circumstances, my Lord, that in view of 116, Lord, will not apply. Now, Lord, second, my second ambit of the argument. This is the first part. Second part is, my Lord, even if, Lord, for argument's sake, Lord, it is a suit for recovery of possession by owner of the property, by 16 annas owner of the property. Defendant is to satisfy the court that he has a right to occupy the property. And what right he has, he has to satisfy the court what right he has to occupy the property, and no eviction decree can be passed in such circumstances.
Yes.
Secondly, my Lord, that right required for investigation of facts for the purpose of starting Order 12 Rule 6. Am I clear to your Lordship? That is the law. That this is the right. This right is required to be adjudicated upon by evidence. Therefore, Order 12 Rule 6 is liable to be rejected. They are to satisfy nothing from the pleading, nothing. Their pleading is they accepted the lease deed. Their whole case is based on the anvil of the lease deed.
Okay.
Their further case is that they accepted. Now, my Lord, third point. Third point is that I have filed a suit. Lord, maybe on misconception of law, because we thought at the time of filing of the plaint that after the expiry of the lease, the structure building constructed by them, because lessee was permitted to make construction on the property. Lessee was permitted to construct the property. Therefore, it has been vested. Now, Lord, I say that
Yes.
I say that your case is that building is yourself. Your case is that you have constructed the building. Your case is that I have constructed the building on the basis of the permission that has been granted in terms of a lease. Your case is, fourth, your case is that the construction was raised on a vacant land. Vacant land was leased out. You admit. Only thing is, my lord, that in my plaint, in the plaint, it is mentioned as along with building, land along with building. Now, is the court precluded to grant a decree on the basis of Order 12, Rule 6, when I admit, the plaintiff admit the case of the defendant? I admit, because this is my alternative case. I press upon alternative case. I am not pressing upon that case. Now, Lord, language is Order 12, Rule 6.
CPC.
Language is or otherwise.
ये
Language, my lord, under Order 12, Rule 6.
CPC টা CPC টা
Lordship got this. Where admissions of fact have been made, either in the pleading or otherwise. Lord, this is otherwise on our part. We are accepting. Lord, we are coming within the purview of otherwise. And admission in the pleading, my lord, with regard to the lease deed. Your right to occupy on the basis of a lease deed. Therefore, we are accepting. Now, Lord, the question is, can a court mold a degree on the basis of Order 12, Rule 6? What molding I am seeking for, subject to my lord's acceptance, in respect of the vacant land, barring the structure, they are at liberty to remove the structure. 3 months' time will be given to them, or 6 months' time will be given to them to remove the structure. Kindly come to Section 108.
Yes.
Lord, Section 108, rights and liabilities of the lessee B, H, my lord. The lessee may, even after determination of the lease, remove at any time while he is in possession of the property leased, but not afterwards.
Yes.
Not afterwards all things which he has attached to the earth, provided he leaves the property in the state in which he received it. Lord, what he has received? Vacant land from the lessor. Therefore, court can direct upon them to remove the building in terms of Section 108 H within a period as your lordship may deem fit and proper. And he is to return this.
Yes.
But exactly a question came up for consideration that court can mold the relief even notwithstanding the pleading of the defendant and plaintiff. Lord, this is a case of the Supreme Court, Lord, 5 bench. না, 4টে বেঞ্চ, চিফ জাস্টিস ওয়াংচু, হৃদয়াতুল্লাহ, রামাস্বামী. Lord, 4 judges bench judgment. 4 judges bench judgment. Plaintiff file a suit for rejectment, alleging defendant is a tenant. Defendant file a suit. Defendant took a defense that he is a licensee in respect of the property. But defendant did not prove the case of a licensee. The plaintiff could not prove the case of the tenancy. Lord, Supreme Court said then you are a trespasser. Either a person may be in possession as a tenant, or he may be in possession as a licensee, or he may be in possession as a mortgagee, or he may be in possession as a trespasser, or he may be in possession as a trespasser by adverse possession. These are the 5 modes. Now, so far, the 4th mode, 3rd mode is concerned, my Lord, Supreme Court disbelieved the case of both the parties. Supreme Court said, Lord, held that this is the departure of the pleading under Order 7, Rule 7 of the Code of Civil Procedure. Departure of the pleading. Supreme Court said the court can, because Lord, court can mold the relief. He cannot direct the plaintiff to file a suit on another on the ground which we are holding, that he is a trespasser. He could not be able to prove that. Therefore, we can pass a decree on the basis of that, because this is a suit for eviction. That is the departure of the pleading of Order 7, Rule 7. Lordship, kindly look to the judgment. Lord, this is, my Lord, 1965 SCC online, Supreme Court, page 111. Lord, facts of the case, my Lord, your Lordship sees. Facts of the case are identical. These 2 cross appeals arise from the suit filed by Chandramani, called plaintiff against the Bhagavati Prasad, the defendant in the court of 2nd Civil Judge Kanpur. The plaintiff alleged he was owner of the house and he had let out the said house to the defendant as his tenant. According to the plaintiff and defendant were friends and enjoyed mutual confidence. As the house was being constructed, the defendant wanted some premises for residence, and so when the ground floor was constructed, he was let in as a tenant by the plaintiff on a monthly rental of rupees so and so. In 1948, the first floor was completed and the defendant took that portion as well as a tenant on an additional rent of rupees 150 per month. By 1950, another floor had been added and the defendant was given the said floor as well as on a further additional rent of rupees 150 per month. Thus, the defendant was in possession of the house as a tenant of the plaintiff on condition he was to pay 450 per month as rent. Defendant continued to pay rent. He was not in arrear in that behalf as on so and so. Thereafter, he failed to pay rent, and so the plaintiff terminated his tenancy and brought the present suit on 30 November 1955, claiming ejectment against the defendant and a decree of rupees for arrears rent to the end of so and so. Future mean profits are also claimed. The defendant admitted that the land over which the house stood belonged to the plaintiff. He, however, pleaded that the house has been constructed by the defendant at his own cost, and that too, he is building on his own. Having constructed the house at his own cost, the defendant went into possession of the house on condition that the defendant would continue to occupy until the amount spent by him on the construction was repaid to him by the plaintiff. Lord, I am correcting myself. His case is that I say that defense was for licensing. No. His case is he constructed at his own cost, and therefore he has a right to occupy the property. According to the defendant, he had spent rupees so and so on the construction of the house. Basing himself on this agreement, the defendant registered the claim made by the plaintiff for ejectment as well as for rent. On these pleading, learned trial judge framed 7 issues. He disbelieved the defendant's version in regard to the construction of the house and found that the agreement set up by him in that behalf on the basis that he had spent the money on the construction of the house himself had not been established. He also disbelieved the plaintiff's case. But he also disbelieved the plaintiff's case, had not been disbelieved the plaintiff's case, had not been disbelieved the plaintiff's case about the agreement as to rent on which the plaintiff relied. According to the trial judge, the defendant had admitted the ownership of the plaintiff. Having regard to the pleadings and the evidence adduced by the parties, he came to the conclusion that the relationship of landlord and tenant had been proved. Having met this specific pleading, learned child had held suit was competent and came to the conclusion plaintiff was entitled to a decree for ejectment as well as for rent. In regard to the amount of rent, however, learned trial judge did not accept the plaintiff's version, considered the question on merits. He held that rupees 300 per month would be reasonable rent for premises in question. That is how he passed a decree for rupees 5,700 in favor of the plaintiff as area rent from 1st April 1954 up to 31st October 1955. Decree further directed the plaintiff to pay damages by way of use and occupation of the rent. Against the decree, the defendant preferred an appeal before the Allahabad High Court. High Court has agreed with the trial judge, disbelieving defendant's version about the construction of the house and about the terms and conditions on which he had been set into possession. High Court was not satisfied with the plaintiff's version about the tenancy between him and the defendant. Having regard to the fact that the defendant has virtually admitted title of the plaintiff, the High Court held defendant must be deemed to have been in possession of the house as a licensee. Lord, on that ground, degree has been, but no party's case that defendant is a licensee. Plaintiff's case is not defendant is a licensee. Defendant's case is not that defendant is a licensee. Pleading, my lord, is silent. That question was whether in such circumstances, Order 7, departure of Order 7, Rule 7 can be. Lordship's held in paragraph number 14, my lord. Paragraph number 14, my lord. In support of its conclusion, in a case like the present, decree for ejectment can be passed in favor of plaintiff, though the specific case of the tenancy set up by him is not proved. The High Court has relied upon two of its earlier full bench decision. In so and so, Allahabad High Court took the view that in a case where the plaintiff asks for the ejectment of the defendant on the ground that the defendant is a tenant of the premises, a decree for ejectment can be passed even though tenancy is not proved, provided it is established possession of the defendant is that of a licensee. It is true that in that case, before giving effect to the finding that the defendant was a licensee, High Court remanded the case because it appeared to the High Court that the part of the case not been clearly decided, but one finding was returned, defendant was in possession of the licensee. The High Court did not feel any difficulty in confirming the decree of ejectment even though plaintiff had originally claimed ejectment on the ground of tenancy and not specifically on the ground of licensee, to the same effect is the decision of the Allahabad High Court in the case of so and so. Lord, ultimately, my Lord, the decree was affirmed by the Supreme Court. Allahabad High Court judgment was approved. Now, Lord, paragraph 19. In the result, the plaintiff's appeal is partly allowed and a decree is passed in his favor, directing the defendant to pay the plaintiff future bean profits from the date of the trial court decree, so and so, date of delivery or possession of the property in suit to the plaintiff. In the circumstances of the case, we direct the parties should bear the cost in both the appeals. Therefore, as far as the mean profits are concerned, my lord, that has been to some extent, Lord, clarified by the Supreme Court. But the ejectment decree, Lord, passed by the affirmed by the Allahabad High Court of the decree of the appeal court, Lord, is confirmed. Notwithstanding the parties pleading in the plaint, notwithstanding the defendants pleading in the plaint about their right to occupy the property. And this is, my lord, the departure of Order 7, Rule 7, the court can mold the relief. Molding the relief, my lord, can be given by the court at any time, at any stage of the proceeding, having regard to the facts of the present case. Now, my lord, identical case, my lord, if your lordship then kindly come to page 70 of my application. Page 70. Lord, because the defendant relied upon their right on the basis of a lease deed. A lease deed, my lord, in respect of the vacant land. Therefore, in any case, my lord, this case cannot govern under the West Bengal Premises Tenancy Act. Unless, Lord, at least one room along with vacant land, if it is given, then it may be argued that premises was let out. But absolutely a vacant land, that was let out. They admitted in their written statement, yes, this is with the authority to raise construction. Lord, your lordship kindly look to page 70. Lord, first of all, my lord, I invite your lordship's kind attention at page 75. Schedule, my lord. All that piece or parcel of revenue-free land containing the area of 10 kathas, 15 chotaks by the little more or less being plot number so and so, Calcutta so and so, municipal number so and now lying at premises number so and so, parts of premises number so and so, piece, which piece and parcel of land is particularly delineated in the map or plan annexed to the indenture of the lease. Now, Lord, what are the conditions? Conditions are, Lord, after the expiry of the period, they are bound to vacate the property. Lord, I am drawing your lordship's kind attention that clause. Lord, first of all, they were allowed, my lord, to make construction on the property. Lordship, kindly come to page 71.
Yes.
Lord, first of all, page 70 towards the bottom. The part of the lease to be observed and performed the lessor doth hereby grant demise unto the lessee all that piece and parcel of revenue-free land. Lord, this is the subject matter of the lease is a bare land, revenue-free land of so and so, fully described in schedule so and so, with rights, liabilities, in and privileges, easements, appendages, etc., etc. As part and parcel thereof, together with full right and liberty to the lessee to erect, construct. Lordship kindly come to erect, construct, set up, fix any building, erection, houses, quarters, structures, shed, godowns, offices, workshop, with the previous sanction of the Corporation of Calcutta by submitting plan or otherwise boundaries, other works and conveniences on and over the demised premises or any part thereof, and to use the same for the purpose of lessee's business and any trade or business ancillary thereto, and for residential and other persons to hold the same unto the lessee from the first day of September 1051 for a term of 15 years. 15 years, Lord, your Lordship kindly come to, that is it will be counted with effect from the day of first day of September 1951. First day of September. Although, my lord, the deed was executed and registered on 4th of October. টিপি একটা দিন একটু আইনের কথা বলে দিন, আইনের কথা বলে দিন। এই কোন জায়গাটা ছেড়ে দিতে বলেছে দেখুন তো, after the expiry, page 74. Lord, page Lord 73, Lordship kindly come to page 74. P, my lord. On or before the determination of the tenancy hereby created, lessee shall be at liberty to dislodge, dismantle, remove, take, carry away for his use all buildings, erection, bungalows, workshops, sheds, structure, plan, machineries, appliances set up, erected or brought in, and upon the demised premises or any part thereof, and all fixtures, articles belonging to the lessee within 3 months from the date of determination of the term hereby created, without causing any damage to the demised land, and after repairing damage, if any, to the demised premises, and after having first paid the rent up to the date of delivery of possession. They are bound to do it. And now, Lord, your Lordship, kindly look to the Lord, the defense of the defendant admit their whole case is based on the anvil of their lease deed. They say that we have every right to occupy the property in terms of a lease deed. Secondly, they said that we have been paying rent to the lessors, and therefore we have a right to occupy the property. This is the case made out in the defense. Now, Lord, this question, Lord, does not require for investigation of facts, because this is purely a question of law. If it is a question involving an investigation of facts, Lord, then trial is needed. If not, then, my lord, I am entitled to have a decree under order 12 rule 6. Now, my lord, your lordship, kindly come to the written statement filed by the defendant. Lord, that is at page my lord, 45. Page 45 written statement and 11th at page 46, my lord. Blood paragraph, first of all, blood, I am drawing your lordship kind attention. This allegation, paragraph 3, the before proceeding to specifically deal with allegations contained in the plaint, these defendants state as follows. These defendants are the successors in interest of Madan Lal Poddar, since deceased, hereafter referred to as the deceased. The said deceased died on 25th of July 1993, leaving behind him his widow, Srimati Sita Devi Poddar, also died on 17th of March 1996. Deceased was a tenant in respect of premises number so and so, the suit premises measuring 10 kathas 14 chatak, who was owned by Nirod Bihari Lahiri, Hindu, governed by the Dayabhago School of Hindu Law. Lord, we purchased the property from the heirs of Nirod Bihari Lahiri. Then, by a deed of lease dated 4th of October 1951, this said Nirod Bihari Lahiri granted a lease in respect of the said premises in favor of the deceased for a period of 15 years with an option for a further period of 5 years commencing from 1st day of September 1951, ending on 31st August 1966. A copy of the lease deed is annexed here too. Then by the said lease, now Lord, the clause has been mentioned. Lease deed clause has been mentioned. All, Lord, I need not read. These are the clauses, my Lord, mentioned in the lease deed. I need not read, my Lord, before your Lordship to eat your Lordship's valuable time. Now, my Lord, your Lordship, kindly come to Lord page, page 54. Therefore, their case is based on this. Statements made in paragraph so far as described ownership Nirod Bihari is true and correct with reference to the allegation so and so. The deed of lease for the purpose of ascertaining the true scope, effect, and purpose thereof in terms of the said deed of lease. This said two-storied building constructed by this defendant belongs exclusively to him and none of the heirs ever had any right. Lord, we are admitting this. We are admitting this. After the expiry of the said initial period of 15 years, we are coming within the purview of the otherwise clause under order 12 rule 6. Initial period of 15 years reserved under the lease, this defendant tendered rent to late so and so. Thereafter to his heirs accepted the same without raising any objection therein. There was no determination of the lease. Consequent therefore, this defendant had no obligation to dislodge so and so, so and so. My Lord, this is the point. Lord, whole case is based on that they have a right to occupy the property on the basis of a lease deed. Now, Lord, the answer is to be given by your Lordship, whether on the anvil of the law they are entitled to occupy the property. Whether this can be decided in law or it can be decided by leading evidence. Now, Lord, your Lordship, then kindly come to, Lord, at page, Lord, then they have said that government premises tenancy act does not apply. I am claiming, Lord, in my plaint, Lord, my schedule of the property is land along with building. Lord, I was under my lawyer was under the impression vested by misinterpretation of his own mind. Lord, but that does not Lord, change the scenario of a legal fallacy. That is to be decided by the court itself. Whether it is a lease governed under Premises Tenancy Act or it is a lease in respect of a vacant land governed under the Transfer of Property Act. But this is a question, purely a question of law. Now, Lord, your Lordship, then kindly come to then, my Lord, page 61 towards the bottom, my Lord. Page 61 towards the bottom. The defendant have been empowered under the deed of lease to induct third parties in this regard. Induct third parties in this regard. Therefore, my Lord, they are claiming a right to occupy the property on the anvil of a lease deed. Lord, now your Lordship, then kindly come to the next point, my Lord. These are the defenses. These are the defenses. আমাদের প্রিন্টারে ইয়ে করেছি, অ্যামেন্ডমেন্ট করেছি, ওই প্যারাগ্রাফটা কোন জায়গাটায় আছে, অল্টারনেটিভ কেস অ্যামেন্ড করেছি। হ্যাঁ,
The grounds taken in the notice, that
But
was
the-
notice for eviction, the grounds squarely falls under the West Bengal Premises Tenancy.
Yes. Right, my Lord. Ground in the notice, my Lord, also as if he is a tenant governed under the WBPT Act. But my Lord, interpretation that notice for eviction is given, need not be given. Supreme Court held, Lordship, by this in the judiciary for last decades, few decades, your Lordship have gone through the judgment of 79 Supreme Court, page 1745, 7-bench judgment. If the lease is expired, then, my Lord, under section 111A of the Transfer of Property Act, Lord, he is bound to vacate, notwithstanding whatever the notice would be. Whether notice is valid or notice is invalid, immaterial. My weapon, Lord, is 111A. Because my case is on the basis of a lease deed. His case is on the basis of a lease deed. Parties fought on the basis of a lease deed. They are claiming on the basis of a lease deed. We are claiming possession on the basis of a lease deed.
But law requires that a notice of eviction be given, whether it is West Bengal Premises Tenancy or transfer of property.
In the case of a, my Lord, contractual tenancy is alive. In the case of a contractual tenancy is alive. But in the case of a lease deed expired, no notice is required. 111A. Lordship, kindly come to section 111A. আরে দাঁড়ান না, ওটা বলছি, উত্তরটা দিচ্ছি, আইনের উত্তরটা তো দিতে হবে আগে। ফার্স্ট অফ অল লয়ের প্রশ্নটা। Lord, first of all, my Lord, I shall answer your Lordship's query, my Lord. Lord, section 111A, my Lord. By A, my Lord, by efflux of the time limited thereby. By efflux of time limited thereby. এই ওই বইটাকে আনিয়ে দিয়ে দেবেন এখানে, আমি দিয়ে দিচ্ছি জাজমেন্টটা। Lord, AIR 1979 Supreme Court, page 1745. 7 judges bench judgment.
Yeah, 1979.
79 Supreme Court, 1745. Lord, I will supply that Xerox in the course of their argument. I need not re-argue, my Lord. I simply, Lord, deposit that amount, deposit that Xerox copy to the court officer. Lord, your Lordship says A. Lordship says the Supreme Court held there in that case by efflux of time, limited thereby. A lease of immovable property determined by efflux of time, limited thereby. Now, Lord, the 108 says that after the expiry, they are bound to vacate. Lord, contract says they are bound to vacate. I read that contract.
Six.
Lord, scope of determination. Here in our case, Lord, here in our case, we gave notice. But a question of law, that is why your Lordship's query is on question of law. Lord, I am duty bound to answer that, being a court officer. But in this case, my Lord, we have given a notice to quit, vacate it. We have an written statement annexed. Lord, they have annexed in the written statement admitting the acceptance of the ejectment notice. Lordship, kindly come to the page 87, my Lord.
There are two questions.
Yes.
One is, you say that it is immaterial whether notice has been given or not. There is no requirement under law to give notice since the lease has expired.
Lordship.
This is your first. Secondly, you have given a notice which is under West Bengal premises tenancy.
Which is under West Bengal premises
Whether,
tenancy.
now the question arises whether the suit filed is under a proper cause of action.
Under proper cause of action.
This is a question.
This is the question. Exactly so, my Lord. Lord, I am deeply obliged. Lord, cause of action is right.
Because if you tally the schedule of your plane,
right, see,
it has a land along with structure.
Lordship.
Probably it has been pursued as if this is a West Bengal under the West Bengal
Premises
Tenancy
Tenancy Act.
But the leased out property is a vacant land.
Yes, my Lord, exactly.
Now you stick to that, even if the schedule is given, that is a wrong schedule. You mold the prayer because the schedule of the lease deed shows that it is a vacant land. It is an admitted position.
Yes.
The
Now, my Lord,
previous
law
case-
is, now, my Lord, what is the law on the subject? Whether my lease, even if I say it is governed under the Premises Tenancy Act, can it be under the Premises Tenancy Act? What is the law? Law is, my Lord, it is governed under the, now, my Lord, whether in such circumstances, the cause of action, Lord, as your Lordship, Lord, rightly pointed, cause of action is for what? For eviction. Cause of action is for eviction. I say Premises Tenancy Act. Now I say alternative case. On the basis of alternative case. Now I became wise. I was fool at the day when the plaint was presented. Lord, I'm telling your Lordship one story. Today it is a story. Lord Honorable Justice C.K. Banerjee, Lord, was a judge of this Honorable Court. Lord, 2 days before, Lord, I got an order under the, Lord, under Article 226, that is for disconnection of telephone line. Lord, I got an order. That order I got it. Lord, then then on the 5 days after that, my Lord, I moved that application. Lord, this is telephone connection matter, my Lord. Your Lordship passed the order. This is your Lordship's order. Lord, same order I want. Lord, then Honorable Justice C.K. Banerjee, my Lord, answered, Mr. Banerjee, on the day when I passed the order, I was fool. Today I am wise. Tell me the facts of the case. Lord, we learned, Lord, from this institution. We learn from this institution, from your Lordships. Everything we are learning. Every day we are learning. Lord, therefore, my respectful submission before your Lordship is this, that in the pleading also, my Lord, we have taken the lease expired. Your Lordship kindly look to that misinterpretation. My pleading is based on misinterpretation of the lease deed.
Okay.
Misinterpretation of the lease deed.
That's all.
Because I was fool on that day. Not today I am wise. When I file an application under Order 12, Rule 6 of the Code of Civil Procedure. Lord, I say that no, their case I am admitting. Now, Lord, otherwise, within the meaning of that, I am admitting that your case I am admitting. And paragraph 3, my Lord, we said that page 16, that the terms of the said lease deed so and so. Therefore, whole case is based on my, in the pleading is based on that lease deed. I am claiming eviction.
Okay.
I am claiming eviction. Now, cause of action, my Lord, means, your Lordship knows, my Lord, cause of action means bundle of facts on the basis of which relief is claimed. Bundle of facts on the basis of which relief is claimed. Now, my Lord, bundle of facts, my Lord, is the lease deed. And on the basis of the lease deed, my Lord, I am claiming eviction. Lord, that is the relief claimed.
Yes.
Now, my Lord, your Lordship, kindly look to the amended plaint, paragraph 31A, my Lord. 31A, page 28. That the plaintiff alternatively states that the said lease deed dated 4th of October 1951 expired by flux of time long ago. Nevertheless, the erstwhile lessee, Madanlal Poddar, since this is intentionally and with due knowledge of the said conditions of the deed, not dislodge, remove, take away, and or all the erection materials set up or created or brought up on the suit premises within the stipulated period of 3 months after the expiry of the lease, even thereafter, and by reason of payment and acceptance of rent monthly in respect of land only, and after the expiry of the lease period, erstwhile lessee remain monthly tenant by payment and acceptance of rent by vacant land only in terms of the Transfer of Property Act. Notice we have given, but land is also there. Therefore, notice cannot be said to be a faulty one. Lord Horihar versus Amsosi, my Lord, Lordship knows 22 Privy Council, 22 Calcutta Willy notes, Lord Privy Council judgment. Their question was, particulars of the property was not given. By virtue of deeds of transfer executed and registered in favor of the plaintiff by 10 shareholders, the plaintiff has become fully entitled. Therefore, they are the owners of the property. Lord, no written statement, additional written statement filed. Therefore, it shall be deemed to have been admitted that I am owner of the property by purchase. Lord, this is a very vital point.
Okay.
Lord, Order 8, Rule 5, my Lord, it speaks about evasive denial. Here, my Lord, in our case, no question of evasive denial, because in our case, written statement has not been filed. After the determination by notice to quit in respect of the bare land in question. Lord, this is my case.
Dude.
Lord,
No. Yes.
now, Lord, your Lordship knows, alternative case I can make out, even inconsistent one. But at the time of leading evidence in the witness box, I must have to choose which case I want to refer, on the basis of which the evidence is to be led. Now, my Lord, exactly under Order 12, Rule 6, my Lord, I am saying, I am skipping out, I am admitting their case. And this is not a case for the purpose of Lord governed under the Premises Tenancy Act. If the interpretation of the lease deed is made in such a perspective on the anvil of the law, then this is governed under the Transfer of Property Act. And my lord, the ejectment notice they have accepted annexed in the written statement. Lordship, kindly note that written statement was accepted. In their written statement, they accepted the notice, and that ejectment notice, my lord, was made a part of the written statement. At page written statement notice, Lord, at page 87. The notice which was given Lord, at the time when notice was given, at that time I was the owner of 10-12 share of the aforesaid premises. During pendency of the Lord, they file an application before the suit court for rejection of the plaint on the ground that other landlords objected to that for eviction. Therefore, suit in the absence without the consent of the other landlord is not maintainable in law. And accordingly, my lord, my plaint was rejected. Lord, against that order, Lord, we went to the High Court, Division Bench. Now, Lord, Division Bench passed an order. Lord, to that extent, I am drawing your Lordship's kind attention. What Division Bench has said. Ache amar kache copy ta. Apnar kache dekhun. What Division Bench has said. Division Bench has said, my lord, substantially, I am telling your Lordship, I am placing that judgment before your Lordship. এই তো এখানে আছে আমার কাছে কপি একটা আছে Lord, I have given on earlier occasion এটা দেখুন যেটা এই জাজমেন্টটা না না এইটা এইটা
It is not yet.
মানে দিয়েছিলাম এটা আমাদের ওটাকে বেশি দিন আমি করছি ভিতরের কাছে আমার Lord, this is the order of the division bench. Appeal was preferred. Lord, order was set aside. Lord, at that time, Lord, it was held that it will be decided whether other co-sharers, landlord object or not, this will be decided in the trial. Lord, now that question is evaporated because of my purchase.
Yes.
And we have stepped into this who's under order 21 rule 10 of the earlier all owners, co-owners of the, that is landlord of the defendant. Okay.
That's all.
Now, my lord, our ownership, lord, lord, in my paragraph 31A, 32, lord, our ownership is admitted by them by non-filing any written statement, even though, my lord, the direction was given to file additional written statement to them. No written statement has been filed. Therefore, my case shall be deemed to have been admitted with regard to the ownership in respect of the property. Now, Lord, your lordship, now, Lord, your lordship, kindly look to, my lord, the order. Orderটা কত পেজ যেখানে amendment allow হলো? Yes, my lord, page 108 of our application under order 12 rule 6. The application comes to principal prayers. To principal prayer, the plaintiff seek deletion of the deceased first defendant who had apparently died prior to the institution of the suit. Second part of the application for incorporating paragraph 31A in the plaint, other defendants are represented, and though an objection has been taken that the suit was incompetent, since it was filed against a dead person, the only interested heir of the first defendant were also impleaded as second and third defendants. Accordingly, same first defendant directed to be struck off. Then, my lord, amendment that was allowed. The amendment sought for by incorporating paragraph 31A in the plaint will not change the nature or character of the suit, nor take away any right that may have accrued to the defendant. The suit was filed in late 2010. Present application has been filed within a few months thereof. There will be an order permitting the plaint to be amended in the manner in red ink in the copy of the proposed amended plaint appended to the petition. Amendment and re-verification should be completed within 4 weeks from date. Surviving defendant will be served copies of the amended plaint within a fortnight of the amendment being carried out. Surviving defendant will be at liberty to file additional written statement within 6 weeks from the date of receipt of the copy of the amended plaint. Lord, they did not file. Therefore, my lord, my purchase as a 16 annas owner in respect of the property is admitted by them by non-filing written statement and denying the amendments made in the amendment. Now, Lord, a legal question. Lord, legal question is, Lord, when amendment is allowed, amendment of plaint or amendment of written statement is allowed, Lord, principles of relation back will apply. In the event, my lord, in the order itself, it is recorded that this amendment will be effective from the date of the order, then principles of relation back will not apply. Doctrine of relation back, my lord, applies, Lord, in cases of amendment ipso facto allowed without any date. Means, my lord, that the alternative case from the very beginning of the presentation of the plaint, that is called doctrine of relation back. Only one judgment, my lord, I can do your lordship again judgment. Order 12, 6. Lord, exactly identical case, division bench, Lord, held whether the defendant has a right to occupy the property before passing a admission decree with regard to order 12 rule 6. So far as the mean profits are concerned, my lord, that is to be adjudicated upon. That part can be adjudicated upon. That part I cannot claim for passing a decree under order 12 rule 6. Or they are saying that we are paying, mean profits will be determined according to Rule order 20, Rule 12. That can be determined according to order 20, Rule 12. Lord, your lordship kindly come to this judgment, my lord. This is exactly an identical case. This is 2023 Supreme Court cases online Calcutta, page 766. এই তোমার সিনিয়র এখানে ছিল, তোমার সিনিয়র জিতেছে। Lord, your lordship kindly come to I am only, Lord, placing before your lordship the relevant part, my lord. I need not read the entire judgment. Subject to what your lordship will say, only the relevant portion.
Yes.
Which paragraph?
Lord, paragraph 15, my lord. The case of eviction of a tenant by the landlord in particular has to be dealt with great caution, more particularly in the perspective of the nature of the tenancy and the protection having afforded under the Rent Restriction Act. The foremost duty cast upon the court is to first find out whether the tenancy is governed by a protection given under the State Restriction Act, or if answer is in positive, no judgment on admission should be passed because of the embargo having created therein. The case of eviction of a lessee under the Transfer of Property Act stands on a different footing than of the State Rent Restriction Act, where certain protection have been given to the tenant against the eviction, what is not required in case of eviction under the Transfer of Property Act. The existence of dual relationship of a landlord and tenant and termination of the tenancy either by efflux of time or by notice served upon the tenant. Lord, if it is efflux of time, then no notice is required. If it is contractual tenancy alive, then notice is required under Section 106. Served upon the tenant under Section 106 of the Transfer of Property Act as sine qua non for passing the decree under Transfer of Property Act. Obviously, aforesaid two instances should be admitted by the lessee in the pleading or otherwise as held by the Supreme Court in Payal Bhattachan Limited case.
Okay.
Lord, then, my lord, your lordship then kindly come to, my lord, the other judgment, my lord, discussed, my lord, paragraph 16. Lord, paragraph 16, the division bench of the Delhi High Court in the case of so and so has succinctly expounded two ingredients for judgment on admission in a suit for eviction of a tenant: the existence of relationship lessor lessee, or entry in possession of the suit property by defendant, and determination of such relation in any of the incidences envisaged under Section 111 of the Transfer of Property Act in the following. Question now is that whether there is any admission or not so as to entitle the plaintiff to have a decree for possession. The factors which deserve to be taken into consideration in order to enable the court to pass a decree in plaintiff's favor as regards possession in such like suit are existence of relationship of lessor lessee, or entry in possession of the suit property by defendant as a tenant, and determination of such relation in any of the contingency as envisaged under Section 111 of the Transfer of Property Act. One of the modes stated therein is by flux of time limited by the lessee. Only on unequivocal admission of the above two factors will entitle the plaintiff to a decree on admission. Admission need not be made expressly in the pleading. Even on constructive admission, court can proceed to pass a decree in plaintiff's favor. Lord, now, Lord, your Lordship, at the risk of repetition, then, my Lord, paragraph 17, paragraph 18, and ultimately, my Lord, on adjudication, Lord, he said, have passed a decree on admission. জাজমেন্ট দেওয়ার দরকার কি আছে? ছেড়ে দিন না, 50 ঘন্টা জাজমেন্ট দেবেন না কেন? কোথায় আছে প্যারাগ্রাফ? Lord, last judgment, only one paragraph. I beg to be excused, my Lord. I want to conclude it today itself. 2012, volume 5 SCC, page 370, my Lord. Race part, your Lordship will look into that. We have a, Lord, 200% faith upon your Lordship. Lord, paragraph 66, my Lord. A title suit for possession has two parts. First, adjudication of title. Second, adjudication of possession. If the title dispute is removed and the title is established in one of the other, then in effect it becomes a suit for rejectment. But the defendant must plead and prove why he must not be ejected. Lord, he is to satisfy the court why he must not be ejected. Lord, paragraph, my Lord, 66. Paragraph 68. Yes, my Lord, paragraph 68, my Lord. 67 and 68. 67. In an action for recovery of possession of immovable property or for protecting possession thereof upon the legal title to the property being established, possession or occupation of the property by a person other than the holder of the legal title will be presumed to have been under in an subordination to the legal title. It will be for the person registering a claim for recovery of possession or claiming a right to continue in possession to establish that he has such a right. To put it differently, whatever pleadings and documents establish title to a particular property and possession in question, it will be for the person in possession to give sufficiently detailed pleadings, particulars and documents in support of his claim in order to continue in possession. In order to do justice, it is necessary to direct the parties to give details. Once the title is prima facie established, it is for the person who is registering the title holder's claim to possession to plead and sufficiently particularly on the basis of his claim to remain in possession and place before the court all such documents as in the ordinary course of human affairs are expected to be there. Only pleadings are sufficient would an issue be struck and matter sent to trial. Where onus will be on him to prove the above facts and documents. Lord, this is the test. Order 12, Rule 6.
Okay.
Lord, these are my humble submissions.
Mr. Aradhan Banerjee, learned advocate for the petitioner, who concludes his argument. Due to paucity of time, hearing could not be concluded. In January. 10 January to larger bench আছে সেকেন্ড হবে তো সেকেন্ড হবে লার্জার বেঞ্চটা হবে 14 তারিখে দিয়ে দাও মানডে 13th.
Lord, treated as a hard in part, Lord. Today I'll leave
13th. In between, nothing will happen.
Yes.
13th.
13th.
Will your lordship be pleased to fix a time?
হ্যাঁ সেকেন্ড হাফে থাকছে তো উপরের দিকে রাখবে এটাকে শেষ হয়ে গেছে সেকেন্ড হাফ আই উইল টেক ইট আপ থ্যাংক ইউ এটা
May I have your lordship's leave to mention?
no mentioning of
14th or Lord, in a state of 13, my Lord.
14th
And if on 14th, my Lord.
14th Mr. Banerjee.
Yes.
Lordship, may I have your leave to mention?
No,
This item
no,
number
madam, no.
Lordship, interim order is getting
Sorry,
expired, Lordship,
tomorrow
on the 6th.
on Monday.
Yeah.